The Royal Commission is now in session. Please be seated.
So I see, Mr Scott, you're appearing with Ms Marsh and Ms Hogendor and with Mr Vial. Yes, thank you.
Commissioner, before we commence today's evidence, can I tender the exhibits in the list for today's proceedings?
Yes. So 5353 to 5663, is that right?
It should be to 5... Yes, that's right, Commissioner.
Okay. The exhibits, as described on the list, are admitted with those numbers. Yes.
Thank you, Commissioner. I call Matthew Rosa.
Mr Rosa, will you take an oath or an affirmation?
The oath, Commissioner.
Okay, if you'd stand, it'll be administered.
Please place your right hand on the Bible. Your response is, I do. Do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thanks, take a seat. Yes, Mr Scott.
Thank you, Commissioner. Mr Rosa, could you please state your full name?
Matthew Richard Wandsworth Rosa, R-O-S-E-R.
Thank you. You were provided a notice to give information in writing and produce documents dated the 18th of October 2022.
That's correct.
You produced a statement in response to that notice dated the 21st of October 2022.
I did.
You produced a supplementary statement dated the 20th of February 2023.
Yes.
Are the contents of your statements true and correct to the best of your knowledge and belief?
They are.
Well, Commissioner, could I just raise one matter I thought I had raised with my learned friend as to a correction to paragraph 76?
Yes, I was going to raise that.
All right, thank you.
Now, you've got some folders there in front of you, Mr Rosa.
I do.
Can you just identify what those folders are?
One is marked Robodebt Royal Commission Hearing Block 4 with the names Tim Ffrench and Matthew Rosa, Witness Bundle Volume 2 of 2. One is the same except it is Witness Bundle Volume 1 of 2. The third folder is Hearing Block 3 AAT Bundle, Witness Bundle Volume 1 of 1. And the fourth one is marked Hearing Block 4, Matthew Rosa Supplementary Witness Bundle.
Thank you. Now, is it the case, as mentioned by my learned friend, you have a correction to make to paragraph 76 of your statement?
I do.
Which statement is that?
The first statement of October.
Okay. And what's that correction?
In paragraph 76, there's an additional superfluous not about 3 lines from the bottom.
Perhaps if we can have that up on the screen so we can see what
Yes,
you're talking
thank
about.
you. It's the not before the word wrong, which should obviously be removed.
Yes, thank you. I'll just ask that that be brought up on the screen. That's on page 14. Now, if we call out paragraph 76,
Yes.
it's the fourth sentence, is it?
Yes, it is.
Okay, and there's a not. Which not should be?
3 lines from the bottom where the sentence ends, the original letter was not wrong, should read the original letter was wrong.
Thank you. Subject to that clarification, is that statement true and correct to the best of your knowledge and belief?
It is.
Thank you. Now, you were employed by DHS as a general counsel, DHS being the Department of Human Services, between 22 May 2017 and 15 November 2019?
I was.
Okay. And what team did you, were you responsible for as general counsel in that capacity?
Initially, on joining the department, I was responsible for a branch that covered FOI, subpoenas and litigation. There was a restructure, I think, late in about 2018 where I became responsible for a branch that traded out FOI and traded in what we call information release, which was an administrative release scheme to allow customers to speedily obtain their own departmental documents.
Okay. And during your time as general counsel, during the period we've described, where were you geographically located while at work?
In Forest, in the Doris Blackburn building in Forest, Canberra.
Okay, thank you. Was there a person in that team called, and by the way, was that team known also as the foil team?
Initially, when it was FOI and litigation.
Thank you. Was there a person in that team known as Brian Sparks?
There was in the litigation team in Hobart, yes.
Okay, so he was geographically located in Hobart?
Yes, he was.
All right. Did he spend much time working in Canberra?
None at all in my time there. He may have before my time.
And is this right? From 22nd of May 2017 until January 2019, you reported to Annette Mussolino?
Yes, as Chief Counsel, yes.
And then thereafter, Tim Ffrench?
Yes.
Thank you. Prior to holding this General Counsel role in the Department of Human Services, were you a partner at Mills Oakley?
Yes, I was.
What area of law did you practice in?
General litigation, specifically Commonwealth focused.
Okay. And would that include litigation in the field of administrative law?
It would, yes.
Okay. And would you therefore have had familiarity with the principle of administrative law that administrative decisions are generally required to be based on evidence?
Yes.
And that administrative decision that's not based on evidence is potentially invalid?
As a general proposition, yes, yes.
Thank you. Now, in your role as General Counsel in the FOIL team, is this right? Sorry, I'll withdraw that. Is this right? Was the FOIL team a team that had responsibility for advising on prospects of appeal against Tier 1 AAT decisions?
Yes.
Thank you. And those advices, were they in a standard form known as an AFAR?
They were.
Okay. And would those Tier 1 decisions include decisions regarding matters under the Robodebt scheme?
They would.
Okay. So would this be right? During your time as General Counsel, you became aware of how debts were calculated and raised under the Robodebt scheme?
I did after the commencement of the litigation by Ms Masterton.
So you didn't become aware of how the debts were calculated and raised under that scheme before that?
No.
Okay, and the litigation commenced by Ms Masterton was in February 2019?
Yes, it was.
Okay, so can you explain how, as General Counsel responsible for the team that provided advice on Tier 1 AAT decisions regarding the Robodebt scheme, you didn't become aware of how debts were calculated and raised under that scheme prior to February 2019?
It had never become an issue for me as General Counsel. In terms of the way the litigation was handled in the department, the AAT Tier 1 or Social Security Appeals Tribunal was basically administered by another branch, a non-legal branch. There was a bundle of paperwork put forward on behalf of the Commonwealth, for want of a better term.
So I'll just stop you there. When you say bundle of paperwork put forward, what are you referring to?
It was not my area. It was done by another branch, so I don't know what was in the bundle of paperwork. I just understand that paperwork was provided to AAT Tier 1.
Right.
Talking about what we'd call the T-docs.
Well, they would be a form of T-docs, yes. Yes, Commissioner.
Okay. Sorry, I interrupted you, Mr. Rose. I just wanted to clarify that.
No, thank you. And so those matters in AAT1 would have numbered possibly somewhere around 10 or 12,000 a year. Decisions that were adverse to the Commonwealth, which was a relatively, as I understand it, small percentage, would then be assessed with an AFAR as to whether an appeal would be taken to AAT2. At the end of AAT2, if there were decisions adverse to what you might call the Commonwealth interests, then another AFAR would be done as to whether the matter would be taken on further appeal, usually to either the Federal Court or the Federal Circuit Court. But that was a system that was, because even the AAT2 numbers that were dealt with by my litigation team and also by external providers instructed by my team, they numbered probably 2,500 to 3,000 to maybe 3,500 a year. That was not something that I was dipping into on a day-to-day basis. That was something that was done by my expert litigators because they were precisely that, subject matter experts in the whole panoply of the litigation that they were running or was being run by external legal service providers.
Did you have a system whereby you would cause your litigators to inform you of significant legal issues that were arising in AAT Tier 1 matters?
Not specifically limited to AAT Tier 1, but it was always clear that if there were significant issues that needed to be elevated in any aspect of litigation, then that should be done, because I would then need to make an assessment as to what, if anything, could and should be done, and whether further escalation was required. So that was effectively a kind of a standing known, for want of a better term.
So what about a regular meeting?
We met regularly every week. Not the entire team. I met with the Deputy General Counsel, who were EL2 Executive Level 2 lawyers who were basically heading up the litigation teams in various geographic locations. We would meet once a week with a formal agenda which included any sort of items of interest or new urgent issues that needed to be raised as the group. The entire litigation team, I think we only met as an entire national team maybe once a month.
Okay, so those once a week meetings with your Deputy General Counsels, was it usual practice for significant legal issues to be raised and discussed?
It did occur, but generally litigation was a relatively quiet component of my branch, particularly in the early days when I was responsible also for FOI. Most of the litigation issues that were discussed revolved around staffing and resourcing and those more administrative type of issues.
All right, so is it your evidence that at no stage during any of those meetings that you recall was the issue of the lawfulness of averaging as it was used in the Robodebt scheme raised?
I don't have any recollection of it being raised until the time of Ms Masterton's claim, when of course we did then discuss it in subsequent meetings.
Okay. Were you aware that there was some substantial media publicity around the Robodebt scheme in early 2017?
I am aware now. I actually wasn't aware at the time.
Okay. So you weren't aware of any adverse media commentary about the lawfulness of averaging before Ms Masterton's litigation in February 2019?
I became aware of media reporting and what you might call publicity, for want of a better term, before the commencement of Ms Masterton's litigation, but not in 2017. I suspect from memory it was sometime around the middle or towards the end of 2018. I can't be certain, I'm afraid.
Do you recall an article by Terry Carney in 2018 about the lawfulness of averaging?
Yes, I do.
Okay, and when did you become aware of that article?
I'm afraid I can't recall whether it was after it was initially published. It was brought to my attention by someone, but I couldn't. I'm afraid I can't recall at what point.
Did you take an interest in the cases he'd decided in the AAT on the issue? Because having read the article, you must have known he had been an AAT member.
Yes.
So did it occur to you to have a look at what he'd actually decided?
It did. I didn't go back and look at AAT decisions, but I did read the articles, and there was I was conscious of increasing media reporting.
But didn't you put two and two together and think, well, there must have been decisions about this, and what did we do with them?
No, I didn't take that step, Commissioner.
Did it occur to you?
Not that I recall.
Thank you.
Can the witness please be shown, and Mr Rosa, it should be behind your tab 23 of the AAT bundle, Exhibit 3482, Doc ID CTH.3761.0001.0223.
Sorry, tab 24?
23.
23. Yes, yes,
Have that?
I have it.
Now, have you had an opportunity to look at this decision in preparation for your evidence today?
I can't say because the name, I mainly went by the name of the applicant, which is redacted, so I'm not sure by the date of Wednesday, the 8th of March, whether it is, I'm speculating that it's either decision.
Oh, we just can't mention the name.
I'm
Well,
sorry.
Write it on a bit of paper for him,
Yes.
for goodness sake. There must be a way of communicating this.
Thank you. I have
Thank you.
that decision.
Now, having read that decision, and I appreciate this is prior to you becoming General Counsel in the department, but having read that decision, do you accept that the effect of it is that the use of averaging, as it was being applied in the Robodebt scheme to calculate debts and raise those debts, was unlawful?
I accept that that was this decision, yes, yes, absolutely.
Thank you. And that the tribunal had specifically directed that no debt or debt component is able to be founded on extrapolations from Australian Tax Office records,
Yes,
and that it had specifically directed that the earnings components of any recalculated debts as may be raised must be based on and confined to any fortnightly salary records obtainable in the exercise of statutory powers to do so. Do you see that?
I recall that, yes, yes.
And are you aware that that decision was not appealed
I am aware, yes.
and that those directions were thereby binding on the Department of Human Services?
Yes, that's correct.
All right. Now, could the witness please be shown? I'll just get the tab number for you in that same bundle, Mr Sparks, but it's Exhibit 3485, CTH.0010.0002.0234_R. Should be a chain of emails. It's your tab 26.
Thank you. Yes, I have it.
Have that? Have you had an opportunity to review this chain of emails in your preparation for your evidence today?
Yes, I have.
Okay. If we go to the last email in the chain, do you see that's date of the 30th of May 2017?
Yes, I do.
That, of course, is just over a week after you've started as General Counsel for the Foil team.
Yes, correct.
The author of the email says that she's doing an implementation where the AAT has requested we obtain income verification from 4 employers in order to recalculate the debt. See that?
Yes.
And having reviewed this email chain prior to your evidence today, do you accept that this relates to the AAT decision that we just discussed shortly?
Yes, I do.
Thank you. And you see that the author of the email identifies a difficulty with obtaining information from one of the employers because they're now out of business, and that the income from that employer formed the bulk of the debt that was an issue.
Yes.
And the question is, please advise what information is to be used in the recalculation. The AAT indicates we cannot use the ATO data. However, there is a significant discrepancy. See that?
Yes, yes, I do.
All right. And then if we go to the next email on the chain on the second last page from Mr. Barrell. And Mr. Barrell was in your team, wasn't he, at the time?
Oh, I'm afraid I have no idea.
Well, the bottom...
I mean, I assume he is, yes, but I didn't have any actual knowledge of that at the time, but his signature block indicates yes, sorry.
Okay, so you don't recall him being in your team?
No,
Okay.
It's a large team, I'm afraid, but I didn't recall every secondee.
Okay. Well, in any event, you can see that his email identifies the issue that the author of the previous email identified about calculating the debt.
Yes, yes.
And asks the question as to what is to be done, in effect.
Yes, yes.
And if we go to the next email in the chain that starts on the bottom of the previous page and call the full email out, please. Now, that's an email from Mr. Sparks dated the 30th of May 2017.
Yes,
You've read that email in preparation for today's evidence.
yes, I have.
Do you agree that the effect of with what Mr. Sparks advises is that the recalculated debt could be recalculated using averaging contrary to the specific direction of the AAT?
That is what his email says, yes.
All right. And just to complete the sequence, if we go to the first page, call out the email on the bottom of the page, bottom of the first page, last four digits, 0234.
Yes, yes.
All right. And do you agree with me that it would appear that the department thereby recalculated the debt in accordance with Mr. Sparks' advice?
That's how it appears to me, yes.
Okay. Now, do you understand that actions taken by officers of the Commonwealth contrary to directions of the AAT may well be a contempt of court? Sorry, contempt of the tribunal, I beg your pardon.
It's certainly possible, yes, yes.
Okay. And can you explain how a lawyer in your team gave advice to members of the department to act contrary to a direction of the AAT?
I can't explain what motivated Mr. Sparks on that occasion, I'm afraid.
Is that consistent with the standards of conduct you expected of your lawyers within your team at the time?
No.
And how did you set the ethical standards for lawyers within your team at the time?
It's not something I specifically focused on. They, as I said, are very experienced litigators. The Deputy General Counsels and the EL2 lawyers had been doing that work for many, many years. I was certainly not aware of any issues or concerns, any issues that would give me any cause for concern on the ethical or professional front. So I did not make it a point to remind them of their ethical duties. They were professional litigators, and I felt quite comfortable that they were following their ethical duties because I didn't see any indication to the contrary. But it wasn't a thing that I raised or tub that I thumped, to use that term.
What level of supervision did you provide Mr Sparks?
I would say relatively minimal, because he was a very senior and experienced litigator who knew the law, and I was, as a general counsel, in a more supervisory kind of role. So I did not give any of my deputy general counsel or senior lawyers what you might regard as day-to-day supervision.
Just on that, knowing the law, this concept of best available evidence, which seems to pop up at every turn in DHS, where does it come from? What's the use of the best available evidence if it's not probative?
I can't tell you, Commissioner, about the genesis of the term, but I think my simplistic view would be the best available evidence is the most probative evidence.
But what if it actually does not prove the point you want to prove?
Then you would regard it as something less than the best evidence, Commissioner.
But if that's all that's available, do you go ahead and use it,
Yes.
even though it's not probative?
It's a question of balance, perhaps, Commissioner, and the Briganshaw scale may come into it, but I don't
Never mind Briganshaw.
want to get into that, Commissioner. But it would have to carry some probative weight to be able to be relied upon, of course.
That's the point, you see.
But there are questions of degree, and if other evidence is available but you still have evidence that carries with it probative weight, then it's evidence upon which you can rely in a decision-making process.
That's the qualification we never see. We just see best available evidence with no regard to what it actually proves. Does it prove something?
I can't speak for the genesis of the term in human services. That's my personal approach to it.
Thank you.
Thank you, Commissioner. Can I ask you this? Have you ever come across any judicial authority to the effect that it is an established principle of administrative law that an administrative decision maker is entitled to rely on the best available evidence, even if it is not probative of the issue?
No, I have not.
Thank you. And that would be because no such principle exists.
I would assume that to be the case. I don't know personally, I'm afraid.
Okay. All right. That can be taken down. Now, Mr. Rosa, do you recall attending a conference of the Australian Institute of Administrative Lawyers in July 2017?
I certainly recall attending. I'm afraid I don't recall the date, but I certainly recall the conference.
Right. Did you watch Mr. Hanks' presentation?
Yes, I did.
All right. Didn't he make clear in that presentation that an aspect of the Robodebt scheme was that it calculated and raised debts based on income averaging?
Yes, yes, he did.
Right. And didn't he make it clear that in his view that was unlawful?
Yes, he did.
Okay. Did that not cause you any concerns at that stage in July 2017?
It did, to an extent. Yes.
I mean, you know who Mr. Hanks is, of course, don't you?
Yes, yes, I do.
Author of a textbook on constitutional law.
Yes, yes.
An eminent silk.
Yes.
Has appeared in the High Court.
I would assume so. I can't be sure. I would assume so.
Has even been briefed to act on the behalf of the Commonwealth in some matters as well.
Again, I would assume that to be the case, or I certainly wouldn't be surprised if that were the case, but I don't know myself.
So you would agree that his opinion as to the lawfulness of the scheme was something to be taken seriously, correct?
Correct.
And do you recall also that he proposed in that conference that proceedings be taken against the Commonwealth to test the lawfulness of the Robodebt scheme.
Yes, that's correct. He was effectively looking for the appropriate matter to bring forward. That was quite clear.
Do you recall him saying words to the effect they were hoping to get something underway, that is, some proceedings underway in the next 6 months?
I don't recall that specifically, but I certainly recall he was looking for that appropriate matter to test.
Right.
I don't recall the timing, I'm afraid.
Okay. So would you agree that at that stage it must have been apparent that the Commonwealth faced potentially some very serious legal exposure,
Yes,
including reputational risk?
yes.
And indeed, if his opinion were correct, that the Commonwealth was taking money from social security recipients that it wasn't entitled to on a massive scale?
If that opinion proved to be correct, then that would also naturally flow, yes.
So in light of what you heard and what you've just agreed with me on, what did you do in terms of bringing those matters to the attention of the relevant people within the Department of Human Services?
Basically, all of the relevant people that I would have spoken to about that issue were at that conference and were as aware of the issue as I was. So there was no need for me to make any further notifications. That word had already gone out.
Right. Did you speak to the people at the conference about the issue?
Yes, I did. I spoke to my peers in the break after Mr. Hanks's session, I recall. Right.
And could you give some names of who you spoke to?
I think Mara Stipnieks was there. I recall Tim Ffrench might have been there as well. Other people, I can't recall the specifics, possibly Patrick Collins. Other people I can't recall, I'm afraid.
Okay. And did they express any views to you on the issue?
The views, the discussion was mainly around the fact that Mr. Hanks was quite expressly looking for a case to use as a test vehicle, for want of a better term, and that was really the focus of the discussion.
After the conference, did you have a conversation with Annette Mussolino about the issue?
Yes, we did have many conversations about the issue as a general proposition, yes.
When?
Oh, I couldn't recall specific instances, but it was a topic for discussion within the Legal Services Division.
Did Ms Mussolino express any words acknowledging the extent of the legal exposure the Commonwealth potentially faced?
Not to me, no.
What words did she use?
There was a variety of discussions. I couldn't recall the content of any particular one, but generally the discussions revolved around whether averaging was an appropriate administrative decision-making basis for raising a debt.
Okay. So you don't recall at all any of the words that Ms Mussolino used in these discussions with you?
Not the specific words, no.
Did you make it clear to her the extent of legal exposure you thought the Commonwealth was faced with?
I think we were all quite clear about the potential exposure, and that it could be significant is probably an understatement on a number of fronts. I didn't feel any need to clarify that because I think it was known.
Did you express any views about whether or not an independent legal advice should be obtained?
No.
Okay. Did it occur to you that would have been a prudent course to adopt?
No, I didn't think it was a prudent course to adopt at the time, no.
Why is that?
This had been a decision, and the department had been operating the scheme in its various forms. I think it was originally OCI, and it might have had some changes in name and changes in iterations for some period of time, and if a legal test case was presented, then that would surely be the time when advice was obtained.
Were you aware of any independent legal opinion on the lawfulness of averaging as it was used in the Robodebt scheme prior to the Masterton litigation?
No, I'm not aware of any.
So, to be clear, an independent legal opinion obtained by the Commonwealth?
I'm not aware of any.
Right. But you had, in effect, an independent legal opinion from an eminent barrister in the form of Mr. Hanks, didn't you?
Well, I wouldn't call it necessarily an opinion, but it's certainly, as in a set-piece legal opinion, but I think his view was clear that there were questions to be posed about the scheme, yes.
Would you agree with me that it was obvious from what he said at that conference that if an independent legal opinion were obtained by the department, there was a substantial chance that opinion would confirm what Mr. Hanks had said about the unlawfulness of averaging in the scheme?
Well, certainly I think there'd be a chance, but whether it would be substantial, I couldn't have said at that time whether that's the appropriate sort of term. Certainly a chance, yes, absolutely.
Well, you knew, didn't you, from the presentation by Mr. Hanks in July 2017 that averaging was being used to calculate and raise debts under the scheme, correct?
Correct.
And you knew from what Mr. Hanks said that that was a process of averaging ATO data, correct?
Correct.
That is data indicating a person's income over a period, usually a year, correct?
Correct, although, sorry, I should go back. Certainly that was a significant part of the scheme. Whether it was a basis for every single debt raised under the scheme, I couldn't possibly say. My understanding of the scheme was there were options for the customer to provide additional material, and in those circumstances where additional material was provided, that may have formed the basis for a decision. I don't know the geometry of how many times it was purely ATO averaging material that was the basis for a debt decision.
Well, did you know that if the customer did not respond to attempts to contact them from the department, that their debts would be calculated and raised using averaging?
I came to be aware of that in the course of handling the Masterton litigation, yes.
You didn't know that before?
I did not.
What do
Okay.
you think Professor Hanks was talking about?
He was certainly raised the issue, and sorry, Commissioner, I may not have been particularly clear, but it wasn't clear to me how many matters were actually being decided by application of ATO averaged material and the role that it precisely played in the mechanics of the scheme.
So you knew there were some, but you just didn't know which ones when it was applied.
I assumed from Mr. Hanks's presentation that there were some, yes, Commissioner.
And the general approach was this significant and credible question of legality having been raised. The general approach was let's hunker down and hope they don't sue or worry about it when they do sue?
No, I don't think that, with respect, Commissioner, is a complete assessment. I think that there were certainly discussions about the issue. I wasn't privy to those discussions, but my understanding was that these matters had been considered and a decision had been made that there was an ability for the department to proceed with the scheme in its then current form.
Sounds pretty much like hunkering down and waiting till they sue, but because no steps were taken in response to this, were they?
Certainly not by me, Commissioner, no.
Or by anybody that you knew of, in terms of getting advice or
Not that I'm
exploring
aware
the
of.
issues raised?
Not that I was aware of in terms of getting advice, no.
All right, thank you.
Thank you, Commissioner. Can I just clarify something you said just a short while ago, Mr. Rosen? Is this the effect of your understanding of the position in July 2017 after Mr. Hanks's lecture?
18, isn't it?
2017.
17, 18?
17.
Sorry, 17, you're right.
After Mr. Hanks' lecture, Apologies.
I'm sorry. Could you start again? I'm sorry.
No, that's okay. I just want to clarify your understanding of the position following Mr Hanks' lecture. Notwithstanding the significant, incredible legal issue Mr Hanks raised, your understanding was because a decision had been made by government to proceed with this scheme using averaging, there was no point at that stage raising with people within the department the need to obtain independent legal advice.
Correct.
Okay. And is that understanding you obtained yourself, or is it something that you obtained after communication with others?
No, that was my personal view and approach.
Right. All right. Now, the Masterton litigation commenced, as we've said, in February 2019.
Yes, that's correct, yes.
Could the witness please be shown, and this should be in the first volume of your large folders, Mr Rosa, tab 28, I think. Exhibit 5378, doc ID CTH.3035.0017.2677.
I'm sorry, tab 28?
Yes.
Thank you. Yes, I have it.
You have that? And my apologies, I've taken you to the wrong document, Mr Rosa. It should be tab 25, same volume, doc ID CTH.3001.0001.0704.
Yes, I have that one.
5375 is the exhibit number. All right. No, that's the wrong one. Sorry, Mr Rosa, I've taken you to the wrong document again. Oh, sorry. It's Exhibit 5480, doc ID CTH.4750.002.15552. Your supplementary volume, I think, Mr Rosa, tab 2.
Third time's the charm.
Yes, thank you, Commissioner. Now, this is an email chain commencing with an email from yourself dated the 12th of February 2019, Mr Rosa?
Yes, that's correct. 2 emails, yes.
Yes. Now, I'm going to ask you about the first one in the chain. It's an email to someone called Matthew Blunt, dated the 12th of February 2019. See that?
Yes, I do.
Who's Mr Blunt?
Mr Blunt was one of the senior executive or managing lawyers at AGS,
Right.
Australian Government Solicitor.
And what was the purpose of this email?
I'm sorry, let me just refresh my memory. It's advising them of the claim that had been commenced by Ms Masterton and arranging for AGS to act on behalf of the Commonwealth interests effectively.
Thank you. Can I just go to the second page of that document, please, and call out the sentence just below the bullet points in the middle of the email, commencing the department is reviewing the file?
Yes?
Okay. Can you explain or assist us in telling us what the purpose of the department reviewing the file at that stage was?
Well, very simplistically, any matter that walks in the door, as a branch manager, you're not going to know the specifics of the particular instance, so you need to get amongst the details, so to speak, nothing more complex than that, to actually work out what has happened and how we got to where we were at that particular point.
Was one of the purposes of reviewing the file to identify whether there'd been any errors in the debt that had been calculated and raised against Miss Masterton?
Yes, yes.
Okay, and what's the purpose of doing that review?
To be absolutely sure that we are, if there is to be a legal contest, that we are talking about a debt that is accurate.
Right. And what would be the usual course if the review identified that the debt was inaccurate?
Then the debt would be recalculated.
Right. And what would be the consequence of that?
As a general proposition, a recalculated debt would effectively replace the original impugned debt that had been miscalculated.
Right. And if the debt was reduced to zero, what would be the consequence of that?
If the debt was reduced to zero, there would certainly be an argument that there is no longer a matter in issue to be no longer a justiciable matter.
And we're of course lawyers here, Mr. Rosa, but there are people watching this that aren't. What are we referring to by not a justiciable matter?
No longer something in contest between the parties that the court need hear.
In other words, that a recalculation of a debt to zero might then mean that the court would not need to determine the proceedings that have been brought by Miss Masterton.
It might, yes.
And if it weren't a justiciable matter, it would actually have no jurisdiction to do so.
Yes, Commissioner.
All right. Now, you understood at this stage that Miss Masterton's proceeding was a significant legal issue for the Commonwealth?
Yes.
And based on your knowledge of the article by Mr. Carney and Mr. Hanks, that there was a significant legal exposure potentially to the Commonwealth brought by this litigation?
Sorry, yes, yes.
Potential for reputational damage to the department and the Commonwealth?
Yes.
And the department would then have an interest in avoiding a judicial determination of the matter, correct?
No, I wouldn't say one necessarily flows from the other in that sequence. The driver for me was to deal with Ms Masterton's litigation in accordance with the legal services directions, and that was my primary role. It wasn't from the get-go to remove a potential contest, not at that stage.
Was there a view within the department, to your knowledge, that it would be desirable to avoid a judicial determination of the lawfulness of averaging?
Not that I was aware of, no.
All right. Could the witness please be shown? This is the first volume of your large volumes, Mr. Rosa, tab 23. Exhibit 1728, doc ID CTH.2001.0012.9991,
I'm sorry, Mr Scott, the tab?
23, I beg your pardon.
23, I'm sorry.
You got that, Mr Rosa?
I have it, Mr Scott, sorry.
An email from Mr Ensby of AGS to yourself, dated the 5th of March 2019.
Correct?
Okay. And you see from the opening words of the email that it is a short email advice on whether a recalculation of the debt in the Masterton matter should be done,
Correct?
and by reference to either averaging or more detailed investigations that may involve the use of compulsory powers without averaging. You see that?
Yes, correct. Option 2, yes.
Yes. And you agree with me that the balance of the document discusses the merits of each of those two options?
Yes.
Okay. If we go over to the second page in the document, please.
Yes.
Where does he say? Okay. If we call out the heading and the paragraph underneath the heading, observations on the preferred options.
Yes, I have it.
It says, we consider that option 2 is very likely to be the department's preferred approach.
Correct.
Option 2 being recalculate without averaging. You agree?
Yes, I agree.
As it is likely to end the federal court proceeding. The only scenario in which option 1 appears to us to be more attractive is if the department had a positive desire to have the federal court issue a ruling on the legality of the use of averaging and or the OCI system. We do not understand this to be the case.
Correct.
Now, do you agree with me that Mr Ensby is expressing an understanding that the department did not have a positive desire to have the federal court issue a ruling on the legality of the use of averaging?
Through Ms Masterton's claim, yes, I agree.
Sorry, could you just elaborate on that, Mr Rosa?
Well, from my point of view, as I said, my brief, as I understood it, for want of a better term, was to handle and resolve in accordance with directions Ms Masterton's claim. And option 2 allowed that possibility rather than having the matter continue on. So I was only approaching it from my perspective as the General Counsel involved in the day-to-day handling of the litigation. My driver was to resolve the claim in the most expeditious manner in accordance with the directions.
Well, Mr Ensby expresses the understanding that the department did not have a positive desire to have the federal court issue a ruling on the legality of the use of averaging.
Yes, correct.
And am I understanding your evidence to be that the department wanted to avoid such a ruling in the Masterton proceeding?
I can't speak for the department. As I said, my brief, as I understood it, was to resolve the litigation as quickly as I could in accordance with the directions. So that was my modus operandi, that was my driver.
So can you assist us as to your knowledge of the source of Mr Ensby's understanding that the department did not have a positive desire to have the federal court issue a ruling on the legality of the use of averaging?
I can't assist you, I'm afraid, on that. I don't know from where that's drawn.
apart from yourself, did anyone other than Mr. apart from yourself, did anyone else in the department deal with Mr. Ensby on the handling of this litigation?
Oh, yes. Mr. Ffrench was heavily involved. Tim Ffrench was heavily involved as either acting chief counsel or by that stage permanently appointed chief counsel. I don't know when that occurred. Annette Mussolino was involved because she was in the operational area. There were numerous other people involved. We had a series of meetings with Mr. Ensby and other people from the AGS team that were attended by a number of human services officers within the SES level. I wasn't the sole point of contact for Mr. Ensby or the sole conduit of information.
So just to be clear, to your knowledge, Mr. Ensby also dealt with Ms. Mussolino on the handling of the litigation?
Yes.
And Mr. Ffrench?
Yes.
Okay. And this email, though, is to yourself, isn't it?
Yes, it is, yes.
And it's not to any of the other people you've mentioned.
No, it's not.
And Mr. Ensby is expressing his understanding that the department did not have positive desire to have the federal court issue a ruling on the legality of the use of averaging.
Yes, he is.
If that was not your position, why did you not correct him?
I didn't think it was a significant issue at the time. As I said, the focus of the email and my focus was the resolution of Ms. Masterton's litigation. That, as I've said, that was my driver, so I was interested in the two options. My personal preference was for option 2 because I thought it would bring the most expeditious finalisation to the litigation.
No view was expressed to you. Is this your evidence? No view was expressed to you by Ms. Mussolino about there being a desire to not have the issue of averaging resolved by judicial determination?
Not that I can recall, no.
Okay. No view was expressed to you to that effect by Mr. Ffrench?
Not that I can recall, no.
Okay. Now, an issue with the accuracy of the debt was ultimately identified, correct?
Yes, absolutely. On at least 2 occasions, yes.
All right. And the first occasion related to double counting?
Yes, it did.
Okay. And what was the double counting issue that was identified?
I didn't identify it, but as I understood the issue, income from one of Ms. Masterton's employers was double counted because I can assume, in separate records, the one and the same employer had been described in 2 different fashions. One, I think, by a company name and in another document by a trading name. And so they were treated as different sources of income when in fact it was the same source and the same income.
What was the other issue?
I don't recall any other issue apart from the double counting, I'm afraid.
So that was the inaccuracy?
That's my understanding, yes.
And as a consequence, a recalculation was undertaken?
Yes.
Without the use of averaging?
Yes, I think the recalculation was undertaken. I can't be sure of this. I might, I'm sorry, Commissioner, be bordering on the speculative, but my understanding is that it was based on the primary material that had been provided in the course of those early days of the litigation.
Well, I'll ask that you be shown this document. I think it's your volume 1, tab 51, doc ID CTH.3008.0025.3948, Exhibit 5398. Do you have that, Mr.?
Yes, I do.
Now,
Sorry, Mr. Scott. Yes, I do. Sorry.
that refers to a meeting in the then Secretary's office on the 1st of April 2019.
Yes, it does.
Right. Now, you're not listed as one of the attendees. Mr. Ffrench is, Miss Morcellino, Miss Carmody, and the organiser is listed as Miss Leon.
Yes, and Ms. Kelly and Ms. Leeming on mine as well.
Yes.
Yes.
Now, just to put this into sequence, by this date, AGS had already provided a draft advice on prospects in Masterton, correct?
Yes, correct.
27th of March 2019.
Yes.
That was to the effect that the process of averaging, as it had been used in the Robodebt scheme, at least in the context of the Masterton matter, was unlawful.
Yes, I think that's a fair summary, yes.
Okay. Now, we ask you to go to the next tab, Mr. Rosa. That should be Exhibit 5399, doc ID CTH.2001.0013.5081.
I have it, yes.
All right. Now, appreciate you weren't at the meeting that was to be held on the 1st of April, but you can see that this refers to the key points for discussion at that meeting that's identified at the start of the email from Mr. Ffrench on the 1st of April.
Yep, that appears to be the case, yep.
Okay. And you can see that a number of options are canvassed
Yes, I can.
as to the process for that recalculation.
Yep,
And one of those options is recalculation on the basis of declarations made in the affidavit.
yes,
And that's the affidavit filed in support of the proceedings by Ms. Masterton's lawyers, correct?
yes.
All right. Can you assist us to understand what that proposal was?
As I understood it, the original approaches under the program to Ms. Masterton invited her to provide additional information apart from the ATO information, the PAYG information, in an instance where that opportunity was not taken up, and I don't mean that in a disparaging sense.
Sorry, just to cut you off, I am cutting you off, but just to be clear, what you're describing is initially what was proposed to Ms. Masterton's lawyers was that the recalculation occur in circumstances where Ms. Masterton provides some further information to inform the calculation.
That was part of the initial process, yes.
And that invitation was rejected by her lawyers?
Yes, that's correct.
Okay, sorry.
But the affidavit that was filed in support of the application contained a significant amount of information in relation to employment income over the relevant period, and that was regarded as being capable of being utilised as another source of information upon which a recalculation could be based.
Right. And in other words, in circumstances where Ms. Masterton, through her lawyers, had rejected the invitation to provide further information, instead what was contemplated was using information she provided in her affidavit on the basis of the recalculation.
Yes, I believe the affidavit was sworn by Miles Brown of the VLA. I can't be sure of that, but the end effect was the same, yes.
Okay, do you have any knowledge as to what particularly in that affidavit was the new information that would assist that calculation?
I couldn't recall without revisiting the affidavit, I'm afraid.
Well, we could do that if you want. I think it's tab 9 of your volume 1, Mr. Rosa. Exhibit 5361, doc ID CTH.3035.001.6.9224.
Yes, I have it.
You have the affidavit there.
Yep.
If you go to the second page, do you agree with me that's an affidavit of Miles Aaron Brown?
Yes, yes it is.
Is that the affidavit we've been discussing?
Yes, it is.
Can you assist us by identifying where in the affidavit is the new information that was to form the basis of the recalculation?
Well, I couldn't tell you which was new information and which was perhaps already been put forward, but the real issue was that the information that was contained within the affidavit and these annexures can be taken globally to be additional evidence upon which the debt could be recalculated. I couldn't say now at this stage it's these particular paragraphs and it's MB 2, 3 and 4 as opposed to 6, 8 and 9, but it was this information for want of its better term, its entirety that enabled a recalculation to be made.
And so, to be clear, are you saying that there was some new information and some information that the department already had?
I can't be clear about that. I'd simply be speculating. I don't know, I'm afraid.
So when you say that the entirety of it could be taken globally to enable a debt to be recalculated, what did this affidavit add that the department didn't already have?
I'm afraid I don't know. But as a standalone document, it was able to be used as the basis for a recalculation.
So why was it necessary to have regard to this affidavit to undertake the recalculation, Mr. Rosa?
I'm assuming that it was because we didn't have sufficient information up until that point, and this provided additional information, but that's an assumption on my part. I can't be sure.
Did you get instructions to support that assumption?
I got advice from customer compliance, which ran the recalculation processes, that this was sufficient to enable them to recalculate the debt, yes.
Did they disclose to you what was the new information that enabled them to undertake the recalculation?
Not that I recall.
Okay. So is this a correct understanding of your evidence? They instructed that it provided new information that enabled recalculation of the debt, but you don't know what that new information was?
Yes, that's correct.
Okay.
Does just seem to be a history of her dealings with Centrelink.
I'm sorry, Commissioner?
Does just seem to be a history of her dealings with Centrelink. Plus a statement that she had declared her income fortnightly.
Much of it is, but then it seems, Commissioner, there might also be information on averaging calculations, income tables prepared by Mr. Brown.
He's taken DHS's calculations and said these involve averaging.
I'm sorry, Commissioner?
He seems to have taken DHS's calculations and demonstrated how they involved averaging. It's just a little hard to find what evidence there is in there, but perhaps we'll get that from DHS at some stage, Services Australia, what it was they relied on.
Certainly, Commissioner, the advice from Customer Compliance and Integrity Group, which had overarching responsibility for the program, was such that this was able to be used as basis for the recalculation, and that satisfied me, given they were the responsible group within the department.
Perhaps it was the best available evidence approach again.
I couldn't say, Commissioner.
Thanks.
Thank you, Commissioner. Can the witness please be shown, it's your tab 56 of that first volume, Mr Rosa. Exhibit 5403, doc ID CTH.2001.0013.5897.
I'm sorry, Mr Scott, the tab again? I'm afraid I
That
missed
was tab 56.
56, I'm sorry. Yes, I have that.
All right. Now, you're CC'd into this email. Do you accept that?
Yes, I was.
It's an email dated the 3rd of April 2019. See that?
Yes,
2 days after the meeting on the 1st of April that we've just discussed.
yes, correct.
All right, from someone called Cherie Harrison,
Yes,
who, if you go to the second page of the email, you'll see she was a National Manager Compliance Program.
yes.
All right. And have you had a chance to review this email in the course of your preparation today?
I don't recall reviewing that email, no.
Okay, do you want a chance to review it before I ask you some questions about it?
Thank you, Mr Scott. Yes, I'm sorry, I've read that.
Thank you. Do you agree with me that the subject of the email is the question of whether or not the proposal to use the affidavit in the Masterton proceeding as a basis to recalculate the debt was consistent with the then current policy of the department?
Sorry, could you repeat the question? I'm sorry.
Do you agree with me that the subject of the email is the question of whether or not the proposal to use the affidavit in the Masterton proceeding as a basis to recalculate the debt was consistent with the then current policy?
Yes,
Thank you.
I agree.
And why would that be important to the department, to your knowledge?
Well, again, I'm somewhat speculating, but it's a government department and adherence to policy is very close to their heart, frankly. I don't want to sound facetious. The operational blueprints that were developed by the department were huge in number, and they were used by all sorts of operational areas to ensure consistency of decision making whilst not being an inflexible kind of impediment to making decisions.
Well, Mr. Rosa, you, by that stage, had worked in the department as a general counsel for over 1.5 years.
Yes.
So you would have had an understanding, wouldn't you, of, at some level, of the importance of consistency with government policy
Yes.
to the department?
Yes, absolutely.
Right. And you had an appreciation, didn't you, of the importance to the department of appearing to act consistently with government policy in the context of this litigation?
Yes, yes.
Because it might, acting contrary to that policy might be seen to be a concession that there's something wrong with it.
Yes, but my personal approach has always been policies within government have incredible uses, but they shouldn't be inflexibly applied simply because they are the policy, and one can't go beyond it and consider sensible and relevant individual circumstances. That's my approach to policy.
All right. Well, do you see at the bottom of the email on the page, going over the top of the next page, there's an acknowledgement that what was proposed, that is to use the affidavit to recalculate the debt, was not the normal approach. And that doing so might set a precedent for future customer contact.
Yes, I can see that.
Right. Notwithstanding those concerns, the view was formed that the debt could be recalculated using the affidavit material.
Yes, that's correct.
In circumstances where it was contrary to the normal approach and might set a precedent for future matters.
That's correct, yes.
Given the importance of policy to government departments that you've identified, does that not seem unusual to you?
Not particularly, no. As I said, my personal view, and I have a very strong personal view about this, frankly, is policy should not be inflexibly applied because it is, quote, the policy, end quote. It needs to take into account, where sensible and appropriate, individual circumstances. It was something personally I railed against in my time as a public servant, the inflexible application of policy to the exclusion of a reasonable, sensible result. I obviously have very strong personal feelings about that. So reading that now, and I'm sure I would have read it at the time, causes me no qualms.
So in Miss Masterton's case, the reasonable thing to do was to accept her word for it that she'd properly declared her income in the past. Well, she said to the best of her recollection she had. So that should be acted on.
Well, it's more, Commissioner, the reliance on the sworn evidence in the affidavit.
Oh, I see. So if all those people who had contacted Centrelink saying, but I declared my income properly, had just put in stat decs, they'd have been accepted.
That's unfortunately, Commissioner, that's not a question I can answer. That's a question for customer compliance and integrity. I don't know the answer.
Mr. Rosa, you know that that the assertion, sworn or not, that income had been correctly declared wouldn't have stood an ice cube's chance in hell against the OCI program, which was designed to average income if there were no other evidence. And if all that the recipient had produced was an assertion, sworn or not, that they'd properly declared their income, there was no way that they wouldn't have had a debt raised.
Well, I assume that's the case, Commissioner, but I didn't work in that area, so I can't definitively say, Commissioner.
Thank you.
Afraid.
See, the way this looks, Mr. Rosa, is that the department was proposing to act contrary to its normal approach and risk setting a precedent for future customer contact in order to make this litigation go away.
Yes, I understand that.
Do you accept that proposition, Mr. Rosa?
I accept the proposition that certainly is how it appears, yes, and also given the ability of customer compliance to say, yes, this is acceptable to us as a basis for a recalculation of the debt, to my way of thinking in terms of responsibility for the day-to-day handling of Ms Masterton's claim, this was an opportunity to finalise the litigation in an appropriate fashion.
And thereby avoid a judicial determination of the lawfulness of averaging.
Well, that wasn't in my thinking. My thinking, as I said, was resolve the litigation as expeditiously as possible in accordance with the directions. That was my driver. And this seemed to be a perfectly reasonable opportunity to do that.
Commissioner, I note the time.
All right, morning tea break. We'll come back at 25 to. Thank you.
All rise. Commission stands adjourned until 25 to 12. Royal Commission is now in session. Please be seated.
And I'm sorry, I just want to take up one more point about my incredulity at the acceptance of the assertion that Miss Masterton had, to the best of her recollection, declared her income properly for the purposes of recalculating the debt. It wasn't even her sworn account, it was her solicitor's affidavit. It was hearsay. So in an evidentiary sense, it was worth even less than your average Centrelink customer ringing up and saying, I declared my income correctly.
That's certainly one view, Commissioner, yes. It was a sworn affidavit of her lawyer, as I recall, Mr Brown.
Yeah, a sworn affidavit as to some hearsay.
Yes, Commissioner.
Okay. And Centrelink officers who got a direct account from Centrelink customers that they had declared their income correctly, there is just no chance, as I said to you before, that they'd have acted on that without other evidence. You must know enough about DHS to agree, surely.
I cannot agree with that, Commissioner, with what I know. I didn't work in that area of the department. I'd truly be speculating, Commissioner. I'm sorry.
Thank you. Yes, Mr Scott, I'll desist.
Thank you, Commissioner. Mr Rosa, can you take up volume 1 of your large bundles, tab 12, exhibit number 5364, doc ID CTH.3035.0016.9824. Do you have that, Mr Rosa?
I'm sorry, Mr Scott, the tab again? I'm sorry, I miss that all the time. I'm sorry.
No worries. Tab 12.
12, thank you. I have it, yes.
Okay. Now, do you agree with me that this is an email chain discussing potential for a report to the OLSC of the Masterton matter?
I'm sorry, just bear with me. Yes, that's correct.
Okay. The OLSC being the Office of Legal Services Coordination
Yes,
within the Attorney General's Department,
yes,
and a report to them would be under the litigation directions of the Commonwealth?
the legal services directions, yes.
Yes. That requires report to them of significant legal matters.
Yes.
We go to the last page in the chain, last email in the chain, I should say.
Sorry, the first in time?
Yes,
Yep,
first in time.
Thank you. Yes, I have it.
Email from yourself to Mr Ffrench dated the 6th of February 2019.
Yes.
Refers to Mr Hanks being retained by Victorian Legal Aid in the Masterton matter.
Yes.
And then there's this sentence. DSS have been notified and stated that they do not want us to report the matter as significant without prior consultation with them.
Correct.
Being a report to the OLSC, as we've discussed.
Yes.
Now, given what you knew as at the date of this email, would this be right? You had a view that it was significant litigation
Yes.
and that it should be reported to OLSC?
Yes.
Okay. We go to the first page, and there's an email from Mr Ffrench at the bottom, dated the 7th of February, where he asks this question: Matt, is there doubt this is significant? See that?
Yes, I do.
And then your response is the next email in the chain at 11:51 a.m, 2 minutes later. Dear Tim, for some reason DSS is extremely cautious about notifications to OLSC.
Yes.
Can you enlighten us beyond what appears in these emails as to why DSS would have that caution and would want to be notified, would want to be consulted with before there be a notification to OLSC?
Not beyond the email, afraid. I don't have any independent recollection. Apart from what's recorded in the email, there's obviously a reference to another matter where there was some reluctance on the part of DSS to report that particular matter as significant, but I don't have any independent recollection of the background that led to the email, I'm afraid.
Right, but you wrote the email.
I did, yes.
You don't have any recollection of what was in your mind at the time you wrote it?
Apart from what's obvious on the face of the email, no, I'm afraid not.
Do you have any independent recollection of your dealings with DSS in relation to reports to OLSC?
No, I'm afraid I don't.
Okay, so you can't assist us at all as to why there would be reluctance on their part to report to OLSC?
Not beyond the black and white of the email, I'm afraid, Mr Scott, no.
Okay. Commissioner, that's the witness's evidence.
Thank you. Ms Hogan-Doran.
Thank you, Commissioner. Just a couple of matters of clarification and one for comment. Ask you to comment, Mr Rosa. You gave some evidence it's your practice to hold regular meetings with your Deputy General Counsels who were EL2s who were heading up the litigation team in each of the states.
Yes.
All that. Who was the Deputy General Counsel that attended those regular meetings with respect to Centrelink matters?
The meetings were in relation to the litigation team generally and all that it entailed. There was never a specific meeting about Centrelink, Medicare, Child Support Agency. It was a general meeting of the Deputy General Counsel and myself.
I'll just stop you there. My question was who attended in respect of Centrelink matters?
All of the General Counsel, Deputy General Counsel were there and could talk about Centrelink matters as was appropriate. There was no designated Centrelink person.
Did Brian Sparks ever attend those meetings?
Yes. Every Deputy General Counsel would generally attend unless, barring emergencies, of course.
All right. You were also asked some questions in which, following Mr Hanks's lecture, do you recall that?
Yes.
And you told the Commissioner that following that there were certainly discussions about the issue.
Yes.
But you said you were not in those discussions.
Generally, no.
All right. How did you know about the discussions?
My recollection is that on occasions where I regularly met with the Chief Counsel, Tim Ffrench at the time, there were certainly references to other meetings and I would As we've seen in some of the earlier evidence, I would be copied in on emails that were subsequent to particular meetings, so I would become aware in that fashion that there had been meetings where these and like issues were discussed.
All right, and do you recall who were in those discussions as it was brought to your attention?
As a general proposition, Tim Ffrench was involved as Chief Counsel. Occasionally, the branch head and General Counsel of Program Advice and Privacy, because
And who was that?
at the time, Mara Stipnieks, but I think perhaps towards the end, someone else had taken over and Maris had left the department. I can't recall who became acting General Counsel. Often Annette Mussolino, given she was a manager in the operational area in customer compliance and integrity, would be involved in these meetings. Craig Storen, I do believe, was involved in a number of these meetings because he also was in the SES, I think, perhaps a band 2 at the time, who was heavily involved in a number of these meetings. The Chief Operating Officer, generally Roxanne Kelly, to the best of my recollection, would have been involved in a number of those meetings, and Secretary Leon as well.
You're asked some questions in relation to just one moment. So you asked some questions in relation to decisions of AAT1, in particular a decision of Professor Terry Carney. Do you recall those questions?
Yes, I do.
And in respect of that, it was drawn to your attention that certain directions were made in respect of the recalculation of the debt.
Yes.
Right? And you were asked in relation to the question, you were asked you were shown that the direction had not been implemented in accordance with that direction?
Yes, I recall that.
And you indicated that you could not think of a reason for not following the direction that had been given.
Yes, that's correct.
Could I ask you to comment as to whether you've been previously informed of this proposition, that in implementing the tribunal's decision, the secretary or their delegate is in effect making a new decision and could have regard to other matters?
As a general proposition, yeah, I'm familiar with the general proposition, yes.
In those meetings with your Deputy General Counsel that you said Mr Sparks attended, did he ever raise that proposition with you in respect of the not giving effect to a direction of a tribunal member?
Not to my recollection, no.
That's all I wish to raise, Commissioner.
Thank you.
May the witness be excused, Commissioner.
Yes. Thanks, Mr Rosy. You're excused.
Commissioner, I understand that one of the folders that is on the table needs to be replaced because the folder that's presently on the table doesn't have
The
Mr.
supplementary one?
That one there, on the witnesses table, I'm sorry.
Okay.
I call Timothy Ffrench.
Oh, I'll put it in my pocket.
Mr. Ffrench, will you take an oath or an affirmation?
I'll take an affirmation, Commissioner.
Right, would you stand, please?
Your response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Yep. Yes, Mr. Scott.
Commissioner. Mr. Ffrench, could you please state your full name?
It's Timothy Lee French.
You were provided a notice to give information in writing and produce documents dated the 10th of November 2022.
Yes, I believe that's the right date.
Produce statements in response to that notice dated the 3rd of January 2023 and 1 December 2022.
And earlier than that, in compliance with the requirement to provide it, I think, by the 23rd of November. There was an amended statement I provided on the 3rd of January to take into account the fresh material that was produced pursuant to, I think, a Commonwealth stamp. But I just would like to make it clear I complied with the requirement.
Of course, yes.
So how many statements are we talking all up?
The amended statement of the 3rd of January is the one that I think we can rely upon, and that contains reference to the appropriate Commonwealth stamp documents.
It's the same statement as the earlier statement you just referred to, but with the correct doc IDs.
Yes, and there were some small amendments, I think, made to correct typographical errors and things like that.
Yes, so in effect, there's two statements.
Yes.
Yeah, thank you. The contents of those statements true and correct to the best of your knowledge and belief, Mr. Ffrench?
Yes.
Thank you. Is this right? You commenced employment with the Department of Human Services in 2012.
That is right, yes.
You left that department on the 15th of June 2020.
Yes.
Thank you. And would this be right? You occupied a variety of legal roles when you were employed in that department.
Yes.
One of those being Chief Counsel between the 24th of January 2019 and 14 June 2020.
That's right.
Okay.
I did take a period of leave before leaving the department and didn't perform any duties for roughly a week before that.
Okay. Before you joined the department, were you a full-time member of the Social Security Appeals Tribunal?
Yes, that's in my statement as well.
Okay. For what period were you a full-time member of that tribunal?
It would have been, it was a little more than 4 years.
Okay. Over what years?
So 4 years prior to 2012 would be 2008?
Okay. So between 2008 and 2012?
Yeah. Yes, that's right.
Okay. And can we take it from your experience in practice as a government lawyer and as a member of that tribunal that you have some familiarity with the principles of administrative law relating to the lawfulness of administrative decision-making?
Yes.
Are you familiar with the principle of law in that area that generally requires administrative decisions to be based on evidence in order to be lawful?
Yes.
Okay.
Obviously, that's a very short summation of the principle there. I think what you're saying is that it would be illogical to make a decision based on no evidence.
Yes.
And I agree with that proposition.
Yes. I simplified the proposition, of course.
I understand.
But it's a principle that just about every administrative lawyer knows.
Yes.
Correct? Okay, thank you. When you were a member of the Social Security Appeals Tribunal, did you encounter any matters where the question of calculating and raising Social Security recipients' debts involved the use of income averaging?
Not to my recollection.
Right. And just
Just to be clear, over 4 years I heard a lot of cases, but I can't recall one that involved averaging.
right, and when we're talking about averaging, we're talking about the averaging of income data received from the Australian Taxation Office,
Yes.
so as to create a
I
figure.
do not recall a case like that coming before me.
Okay, thank you. Now, would I be right in understanding that until you took up the role of Chief Counsel in 2019, you had no direct involvement in matters involving the Robodebt scheme?
Yes, that's right.
Okay. What areas did you work in the department prior to becoming Chief Counsel?
Before, I think I became an SES officer in 2015. At that point, I took up a position, as it's in my statement, as the General Counsel for Employment Law and Customer Compensation. And that was a little bit of a departure from the path of my career, intentionally so. I wanted to do something different. I performed those duties for around about another 3 years, and then I took on the responsibility for freedom of information and lost the responsibility for customer compensation. After that, I went to the NDIA for a short period of time. It was meant to be for 12 months, but it was 3 months in the end, where I managed or tried to set up processes and practices to manage the expected increase in AAT applications. So during that period of time, I didn't have anything to do with DHS or Centrelink litigation, and that was partially because it was a career decision.
Okay. Did you have any awareness of the adverse media publicity concerning the Robodebt scheme in early 2017?
Yes, and I have said so in my statement.
Okay. And that publicity involved criticism of the use of income averaging?
Yes.
That it was unlawful?
Yes.
Okay. And you attended, did you, in July 2017, the Australian conference of the, sorry, I'll start that again. Did you attend the conference of the Australian Institute of Administrative Lawyers in July 2017?
The Australian Institute of Administrative Law, yes, I did attend that conference. Again, that's referred to in my statement. And in that conference, I heard Mr. Hanks detail more or less the plan of attack that they eventually followed in the Masterton and Amato litigation.
That is, he detailed the argument regarding the unlawfulness.
Yeah, and the use of judicial review to achieve a public policy end.
Yes.
And look, you can stop mentioning that it's in your statement. If anybody's going to accuse you of recent invention, I think you'll know about it.
I'm sorry, Commissioner.
That's all right.
So, from your response to my last question, it's clear you've got a distinct memory of what Mr. Hanks said at that presentation in July 2017. Would that be a fair summary?
Yes.
And in light of that, and your experience in social security law, did you have any concerns about the lawfulness of the Robodebt scheme?
Yes, I did.
Can you describe the extent of those concerns?
I think those concerns at that point in time were similar to the concerns that other interested observers, knowledgeable and interested observers had about the Robodebt scheme. I wasn't privy to whatever was happening in the legal area in the department I was in relation to Robodebt, but from where I sat and from what I heard, yes, I had concerns.
Okay. Did you discuss those concerns with anyone?
I don't recall speaking to... I recall speaking to some colleagues about that. I don't recall speaking to Ms. Mussolino or Mr. Stipniks or the people who are responsible for the department's position with respect to Robodebt, if that's where you're going.
Okay. You're aware, aren't you, that at no stage prior to February 2019 did the Department of Human Services obtain any external legal advice on the lawfulness of income averaging as it was used in the Robodebt scheme?
Yeah, I'm aware of that.
Okay.
Well, that's based on what I know. I mean, I haven't been following these proceedings for 3 months. I don't know what's come out. But no, my understanding is just that there wasn't any.
Okay. And I appreciate you weren't Chief Counsel in July 2017.
Mm-hmm.
But had you been Chief Counsel in July 2017, would you agree that the sensible and prudent course would be to strongly recommend to the Secretary of the Department that an independent legal opinion be obtained as to the lawfulness of the scheme?
I think it's a reasonable statement to make that when there was a significant amount of adverse criticism accompanied by academic criticism of this scheme, it would have been prudent for the department to have obtained further advice about the legality of the scheme. So the answer to your question, I think, is yes.
Okay. Based on your experience in the practice of government law, can you enlighten us at all as to anything about the dynamics of working within a department's internal legal unit that might affect a decision whether or not to get external legal advice about a matter such as the matter that was raised by Mr. Hanks in his paper?
Well, lawyers act on instructions, so if those instructions aren't given, the advice wouldn't be obtained.
Right. Okay. Well,
I think that's the fundamental issue I would see there.
okay. But as appreciate things had moved on significantly by February 2019, when you ultimately were in the role of Chief Counsel. Does the role of Chief Counsel not include capacity to make recommendations to the department?
Absolutely.
And that is, if, for example, a significant legal issue has been identified, to, even without instructions, recommend to the Secretary that legal advice is, independent legal advice is needed?
Yes, I did that in Masterton in seeking the prospects advice. I spoke to the Secretary directly, and I know that that's not your question to me, but to give you an example, that's the sort of thing I would expect a Chief Counsel to do.
Okay.
Well, then going back to the dynamics, can you explain what about the dynamics might have inhibited that?
Commissioner, there was a different secretary, I think, in 2017. That may have inhibited or dissuaded persons from providing advice that they might otherwise provide, but I'm speculating. I wasn't privy to the dynamics of that.
Well, you were in the department in 2017, correct?
Yes.
So you, to the extent there was any relevant dynamics in the department, you'd potentially be aware of them.
Yes.
Can you comment then on what the dynamics in the department were like in 2017?
It's a short question, but a big one. I think the dynamics in 2017 were not the kind, well, we're talking about culture, I think, culture and leadership. Those things at the time were not conducive to a proper examination of issues relating to this particular program, given that I think many people were determined to achieve a particular outcome for government. Once they'd reached that state of mind, I think that the inquiry, the honest inquiry into issues like the ones you're raising, was not something that that was fostered by that culture. I think it was, I feel, that sounds terrible, I realise that this is a significant occasion, I shouldn't say I feel, I believe that the culture and environment at that time prevented people from asking the questions that they should have asked because of fear that those questions would be seen as potentially impertinent, unnecessary, or that the people asking those questions may have been presented as being blockers to the achievement of particular objectives.
Were there any particular individuals that, on your observation, contributed to that culture that you just described?
Yes.
Who?
Melissa Golightly.
Okay, anyone else?
Well, to the extent that Ms. Golightly's behaviour was enabled and fostered by another, it would be the Secretary.
Okay. Anyone else?
Not that come to mind. I think obviously there were many more executives in DHS at the time who may have shared that kind of approach, a command and control approach to the management of the department. But the ones that immediately come to mind are the people I've just described to you.
Okay. Now, Mr. Ffrench, did you become aware of decisions of the AAT in 2017 through to 2019 commenting on the lawfulness of income averaging in the Robodebt scheme?
I did. I think that was a matter of some media attention as well.
Okay, when do you recall first becoming aware of those decisions?
It would have been before 2019. Again, I think that Mr. Carney might have been writing about that. I don't think it came out of Mr. Hanks's article. Probably it would have been the media attention prior to 2019 and Mr. Carney. I did hear that there were adverse decisions being made in respect of Robodebt, and that would have been, I can't recall when, before 2018, and that the then litigation branch was in a regular process of conducting conferences with the program area at the time. This wasn't something that was in my area, and I should be really, I should give you this information as well. I was in an area that was very, very busy at that time. The employment law area that I was responsible for was also responsible for industrial relations and the negotiation of a new enterprise agreement, which was very consuming. I had heard snippets about adverse decisions being handed down, and I am aware, or I had heard, that there were conferences in relation to those adverse decisions at the early stages, I think, in the Robodebt scheme.
Just to be clear, did you have an awareness of adverse decisions in the sense of decisions containing reasons specifically saying income averaging is unlawful?
So, to the extent that I based this understanding on the media that I read, then yes, because that was what Mr. Carney was saying.
Okay, and when you say what Mr. Carney was saying, is that a reference to his article in 2018?
I can't tell you the date, but I recall reading media around this issue and the fact that Robodebt decisions were being set aside by it may have been the SSAT, but what is now the AAT.
Did you have some knowledge of Mr. Carney's expertise and knowledge of social security law at that time?
Oh, only what I read in the media.
Okay. You didn't encounter him when you were on the tribunal?
No, I didn't.
You mentioned conferences between the litigation area and the program area, I think you said.
Yes.
What sort of conferences?
I understand that, and this is information that I've picked up over various points over the years. I understand that the litigation branch, at the time that Robodebt decisions started to be overturned, would have regular conferences with with the business area responsible for Robodebt discussing those decisions. But the information I have is secondhand. I mean, others would be able to confirm that. But that's what I heard. And that those conferences went on for a period of time. I'm not sure for how long or when or if they stopped.
Okay. So, by the time that you became Chief Counsel, had you formed a view as to the strength of the department's arguments as to the lawfulness of averaging as it was used in the Robodebt scheme?
No, and I say that because I hadn't been given full details of the department's position. I hadn't fully engaged with the department's position before starting. I think that Mr. Stipniks gave me the details, such as they were, of the department's position maybe 2 weeks or 3 weeks after I commenced.
Is that the event on the 6th of February 2019 that you refer to in your statement at paragraph 115? That should be in volume 1 of the large folders that you've got, Mr. Ffrench. Tab 4, perhaps.
Sorry, what paragraph was it?
115, I think.
115. Yes.
Okay. And that refers to various documents at footnote 60 of
Yes.
that statement that were provided to you by Mr. Steepnex.
Yep.
And you also refer to others informing you of the position in paragraph 122, I think.
I think paragraph 122 is a reference to the material in 116, I think.
Yes, thank you. And so Ms. Mussolino also communicated matters about the position of the department to you, correct?
Yes, I think we'll talk in a moment. I think about some of the things that she had to say about the department's position, but yes, I did have conversations with her about that.
Okay. And then ultimately in paragraph 123, if we call that out, please. Does that summarise what you understood the position to be based on those documents Mr. Steepnex provided you and what others told you, including what Ms. Mussolino told you?
I think that's a summation of the material that was provided to me. I don't think that was informed by discussions with Ms. Mussolino. Some of that material was from Ms. Mussolino, though, when she was Chief Counsel.
I see.
That's my best summation of my understanding of the department's position.
Okay. So having had it articulated to you and the documents in which it was articulated having been provided to you, did you then form a view as to the strength of the department's position?
I considered the department's position to be quite, how can I put this? It wasn't a strong position. I could see the arguments that had been put. You can see here a lot of it is about things that have taken place after an assessment has been made based on ATO PAYG income. If you read this, it seems like it seems almost reasonable unless you come back to that threshold issue about the evidence that's been used to base the decision.
Yes, that's what it didn't address at all. That is the sufficiency of evidence to raise a debt.
That was the department's position for a number of years before I became acting Chief Counsel.
Yes. No,
But just to be clear, when at this point in time, I think I'd been in the position for 4 weeks and I was in an acting position of 3 months.
yes. No, but I'm just trying to understand what you said in response to one of my earlier questions, which is that what you pointed out was completely missing from the position as articulated to you was how the use of averaging under the Robodebt scheme could be lawful consistently with the principle that administrative decisions are generally required to be based on evidence.
And you'd be aware that the Solicitor General actually examined the issue of inference quite extensively. If you read this position that had been adopted, it seems heavily based on an assumption that if you don't respond, there's an inference that we can use to base the decision. And what the Solicitor General said rightly is that inference can't be used to plug the gap in evidence.
Yes.
So it seems awfully simple now, but I think that there was further examination of the legal position that was required before people would accept that this entrenched view that the department had at the time was wrong.
Okay. So just, if we could step that through, firstly by reference to what the Solicitor General said, and then
Yes.
I'll ask you about the extent to which that entrenched view about inferences had been expressed to you by anyone. So I'll take it in steps, okay?
Sure.
So firstly, what the Solicitor General said, we don't need to go to the opinion. I take it you're clearly
Yes.
familiar with it. What you're referring to in terms of inference is the permissibility of an inference that what the department had asserted as to the existence of a debt in the initial correspondence sent to recipients under the program was likely true because of a non-response by the recipient.
No, what I'm saying is that the department's position at the time was that when a recipient had received notification of ATO PAYG income that was proposed to be used to reassess their entitlement, where that recipient did not respond to that notice, the argument here is that that failure to respond gives rise to an inference or a permission anyway to use the information that has been put to the recipient.
Yes.
Now, I'm couching it in terms that probably fit more neatly into what the Solicitor General ultimately said about this. At the time, I don't think anyone articulated it that way to me, but if you read the material that was created at the time, that seems to be what people were thinking.
Right, so you inferred that's what people were thinking.
Yeah.
I'm not meaning to be critical, I'm just trying to ascertain.
I'm sorry, I'm just trying to think about that. So, yes, I think people thought that if a recipient had received a notice detailing information that was proposed to be used and the recipient did not respond, there was permission for some reason given to the department to make a decision based on that information.
Okay, is that something that you've been positively told that people thought, or is that something you inferred?
That would be something I've inferred.
Okay, but just to be clear, what the Solicitor General did with that issue was to refer to the well-established principles in the case of Jones and Dunkel, correct?
Yes?
Which deals with the permissibility of those types of inferences that you've just described.
That's right. And I think he commented that, words to the effect that you can't plug the gap.
That's right. And that's a proposition that comes from Jones and Dunkel itself, correct? And Jones and Dunkel is a case that was decided by the High Court in the middle of the last century.
It's well known. I don't know the exact date, but yes, I've referred to it.
It's a case that law students are taught about in undergraduate law, isn't it?
Yes.
Okay, so it's not that type of form of analysis, that is, that the non-response can't plug the gap in the evidence, is something that is a long-established proposition of law, correct?
So I haven't done my research on that particular point. I do accept that Jones and Dunkel is a well-established proposition. I'm not sure if I can go further and say that I agree with you without having informed myself of what you're saying.
Well, that idea that the non-response can plug the gap in the evidence.
As opposed to reinforcing something that might already be there in some form.
Yes, Commissioner, that's what I understand, and that's ultimately what the Solicitor General said.
And that whether or not the non-response can plug that gap as distinct from reinforcing what's already there in the evidence, that was a specific issue that the High Court considered in Jones and Dunkel. You aware of that?
I haven't read Jones and Dunkel for quite some time, so the answer is no. I do know that the Solicitor General commented on this particular issue in the opinion that was delivered.
Okay, so can I just clarify that until you read the Solicitor General opinion, you weren't aware of the analysis of the High Court in Jones and Dunkel about whether or not non-response can plug the gap in the evidence as opposed to reinforce what's already there?
So I think what I'm saying is that this position seemed to be based on an understanding like that. The question that was put to the Solicitor General ultimately sought his view on that, along with a range of other things. Did I read the High Court decision in Jones and Dunkel any time between February and September? No, I didn't.
Were you aware of, though, the principles?
I was aware of the principles.
You were,
Yes.
including that, and I don't have Jones and Dunkel in front of me, but to use the language we've been using, what Jones and Dunkel clearly decides is that a non-response can't be used to plug the gap in the evidence.
My understanding of Jones and Dunkel at the time was not as clear as that. I was aware of Jones and Dunkel as a proposition that if material is put to a witness and a response is not given, you may draw an adverse inference. It's an inference though. So I don't think that, despite not knowing specifically that that statement was made in that case, I don't think that my knowledge was awry, because an inference isn't evidence.
Yes. So regardless of your knowledge of the finer points of Jones and Dunkel,
Yes.
you had a general understanding as a lawyer that a non-response to this letter wouldn't ordinarily be a basis to plug a gap in the evidence.
Yes.
Okay, thank you.
Look, it's a matter of common sense, isn't it? If you haven't got evidence of something, the fact that someone hasn't denied its existence is hardly going to prove it for you.
I agree.
Okay, so, and the other thing I just would like you to confirm, Mr. Ffrench, is that departmental position that's summarised on the page that's called out on the screen, which we've been discussing at some length. Is this right? To your knowledge, it was not supported by any judicial authority that you were aware of? Sorry, I'll rephrase the question. It was overly broad. In the articulation of the department's position to you, at no stage did those articulating that position to you identify any judicial authority to support the position?
I'm not sure if that's true. In fact, I think that there was some reference to cases in relation to, for example, unlawfulness, and when a decision made on a factual question might amount to an error of law. In fact, I recall that there was reference. There was reference, I think, to the ARC commentary on that, and in that there is reference to cases. I'd have to go back and look at the material that was given to me to see. There might have been reference to other decisions as well.
Okay, but you're referring to cases that talk about, am I right, general propositions of law?
Yep.
I'm asking you about specifically the use of income averaging to calculate and raise debts.
That's correct.
No judicial authority.
I'm not aware of any.
Okay. And none were communicated to you by those who articulated the department's position?
That's right.
Right. So would this be a fair summary of your understanding of the department's position at the time that it was communicated to you in February 2016 and thereafter, that you understood it to be a weak position, correct?
I think so.
That essentially relied on a novel argument that was untested by judicial authority?
I'm not sure what the novel argument was, but there wasn't any judicial authority to support a proposition that income averaging in the social security context was lawful.
Okay. Well, that's the novelty I'm suggesting.
Then we agree.
Okay, thanks.
Richard, just before my friend passes, I was not quick enough to rise. He put that last passage in the context of being told in February 2016. I think he meant to say February 2019.
Yeah, you did say 2016. I thought we'd probably all understood that you meant 2017, but thanks, Ms Hagendorn.
My apologies. It was 2019 we're talking about, isn't it?
Commissioner, not February 2017,
2019.
2019.
Yes.
In relation to the material that was given to me, it was 6th of February 2019, yes.
Yes. That was the... So your understanding of the strength of the position that you've just agreed to in my earlier questions was your understanding in February 2019, correct?
That's right. There are arguments, but my assessment was that the department's position was weak.
Thank you. Now, in February 2019, the other thing that happened was the Masterton proceedings were commenced, correct?
Yes, that's right.
And you were involved in actions taken by the department in relation to those proceedings, correct?
Actions is
It was a hopelessly imprecise question, I'm sorry.
I'm trying to unpack it, sorry, Mr Scott. What do you mean?
I'll be more precise. You were involved in the provision of instructions to the Australian Government Solicitor in relation to those proceedings.
That sounds like a simple question. I'm sorry, I'll just expand on how that works. So we have internal clients, they provide instructions to the internal legal area. In cases like this where we're required to engage into external legal services, those instructions are then provided to the external legal service providers. So yes, I conveyed instructions on behalf of the internal client.
Yes. Sorry. Thank you, Mr Ffrench. Can you comment on whether or not, at that time, anyone within the department expressed any concern to you about the implications of the Masterton litigation?
I think it was apparent to people that the Masterton litigation was being conducted in accordance with Mr Hank's stated program of using judicial review to challenge the scheme. Did anyone express concern about that? I can't recall anyone saying, let me think about that. I think people were aware of the significance of the Masterton litigation. Whether they expressed concern, I can't say, but I think that was well known. You will see, and I won't say I've spoken about it in my statement, that the Masterton litigation, once it was filed, was communicated to the Minister, to the Secretary, and to DSS Legal. I think that speaks of the significance that we saw of it.
Okay. What about, do you recall there being any concern within the department about the implications of a judicial determination of the lawfulness of averaging in the scheme?
I don't recall anyone expressing that particular concern to me.
Okay. Can I just ask?
As a concern. I mean, it's an obvious implication of this kind of case being run, but I don't recall a concern being conveyed to me like that.
Okay. Well, there was obvious potential for substantial reputational risk posed by a judicial determination adverse to the department.
I think that's an obvious statement.
Okay. And obviously potentially had rather large budgetary implications.
It may have. It wasn't something that wasn't something that was on my mind at all, I must say.
Okay. All right. What about the potential for those who had been involved in the program to suffer professional embarrassment if there were a judicial determination to the effect that the program was unlawful?
That concern was never raised with me. It's not, and it wasn't one that I ever really thought about.
Okay.
It wasn't relevant.
Okay. Can the witness please be shown? It's your tab 23 of volume 1 of your large folders, Mr. Ffrench. Exhibit 1728, doc ID CTH.2001.0012.0091.
Yes.
Now, this is an email from Mr. Ensby to Mr. Rosa. I appreciate you're not a recipient of this email.
I did receive it.
Oh, you did?
Mr. Rosa passed it to me.
Oh, thank you. Well, then I will ask you about it. Now, you're clear, the way you just responded to my earlier question sounds like you're familiar with it?
Yes, I am.
Okay. And you can see that the email refers to the material filed in the federal court proceeding showing that the amount that the debt that had been sought from Ms Masterton was inaccurate. That's under the heading background of Mr Ensby's email to
I'm
Mr.
sorry,
Rosa.
Mr. Scott, I'm just trying to familiarise myself with this particular document.
Sorry, I'll let you read it.
Let's keep going. If I need to go back to it, I will.
Okay, so just to be clear, we're talking about an email from Mr. Ensby to Mr. Rosa dated the 5th of March 2019?
Yes.
Okay. And can you see just under the second paragraph, the heading background?
Yes.
It says, the material filed by Ms Masterton in the proceeding shows that the amount of the debt that was sought from her through the online compliance initiative was inaccurate. The debt that was raised included an element of double counting. See that?
I'm sorry, is this under background on the first page?
It should be. Are you looking at tab 20?
23.
Sorry, 23.
And the second paragraph we have previously discussed and we understand that the department agrees?
So it was the first paragraph was just read to you, the material.
Okay. Thank you, Commissioner.
Now, do you agree that's what it says?
Yes.
Okay, thank you. Now, do you have a recollection of what the double counting that was revealed by the affidavit material was?
I have a recollection that the double counting involved employment income from the same source that was recorded twice because the source was described by both its trading name and its corporate entity.
Okay, thank you. Do you have any knowledge of the circumstances that led to the identification of that double counting?
I think that when the Masterton application was filed, it became apparent to a lawyer working in the litigation branch that there had been double counting. I understand that double counting did happen from time to time in these kind of debts. That's my understanding.
Who's the lawyer you're referring to?
Mr. Hester.
Now, if we go back to the start of the email, just under the words, Dear Matthew, call out that first paragraph. You see there that the email notes that what has been raised for advice was effectively two options as to how the debt might be recalculated after it had been identified that there was a need to recalculate the debt.
That's right. I think AGS may have initially put to us that the debt should be recalculated, and that would have been in February. But yes, that's correct.
Okay. Now, the two options are option one, to do it with reference to averaged income, and then option two, after more detailed investigations, without averaging. You see that?
That's right.
And then we go to the next page under the heading Observations on the Preferred Options.
Yes.
See that it says, we consider that option two is very likely to be the department's preferred approach, as it is likely to end the present federal court proceeding. The only scenario in which option one appears to us to be more attractive is if the department had a positive desire to have the federal court issue a ruling on the legality of the use of averaging and or the OCI system. We do not understand this to be the case.
Yes.
Now, what Mr. Ensby seems to be communicating is that he did not understand that the department had a desire for a ruling on the legality of the use of averaging.
Yes.
And another way to put it is that the department had a positive desire to avoid such a ruling.
I'm not sure if those two things amount to the same, but I think it's clear to say that the department didn't want I understood the department didn't want this matter to be determined for those reasons, yes.
Okay. And how did you obtain that understanding?
This statement here, I believe, is a reference to a case conference that was held with Ms Mussolino and Mr Ensby, myself, and maybe Mr Rosa. And I can't tell you exactly when. There are a number of conferences with AGS and Ms Mussolino, before this anyway, and it would have come out of that.
Okay. And can you assist us as to what was said at that conference that formed the basis of the understanding that's described in this email?
I couldn't remember exact things that were said. No, I can't.
Well, your evidence just a moment ago indicated there was something that was said that gave rise to this understanding.
Sorry, the precise words I can't.
The effect of what was said, who said it, when, as best you can.
I'll be expansive. As best as I can recall, there was a case conference held before this advice where Ms Mussolino said words to the effect that we don't wish to treat this as a test case. What other options are there, that sort of thing.
Okay. And why, did she explain why she didn't want it to be treated as a test case?
I should be really careful here. I don't even know if she used that precise that precise terminology, but it was clear that the department didn't see that it didn't wish for the matter to go to a determination. There's lots of reasons why clients might want to take that position. I can't remember exactly what it is that Miss Mussolino said at the time. Yeah, I couldn't say anything more than that.
But it was something that she said that gave rise to your understanding that there was a desire not to have a ruling on the determination of the lawfulness of averaging.
A desire not to have this matter run to a hearing, yes, and that was the same understanding that Mr Ensby formed in this advice.
Okay. And did Miss Mussolino at any stage say anything to indicate why that desire existed?
I'm just trying to think back on this. I can't recall. No, I can't recall.
Okay.
You said there were lots of reasons a client mightn't want a matter to go to a determination. Can you think of a respectable one here?
Its determination will be costly. The legal services directions require government to consider options other than a determination. As came out here, another option available to you to determine your position would be to get authoritative legal advice. And we can talk about, if you wish, whether that was a better option. I think there are a number of things that would prompt a decision maker not to wish to move on with litigation. It's uncertain. You don't know what kind of decision you're going to get. It can be time consuming. Our best estimate in March was that we'd have a hearing in 6 months. As it turned out, this matter, or the Amato matter, wasn't going to be heard until December. Following on from that, 3 to 6 months before you have a decision handed down. All of that's costly and uncertain. And I can see a number of reasons why a client might not wish to go through that.
Okay.
But can I just stop you a minute? It must have been apparent that this thing was going to be litigated sooner or later.
Yes. I mean, it was plain that whatever happened with this particular case, there would probably be another one.
So why not?
Because this particular one had some obvious errors with the calculation itself. We had advice from AGS that needed to be corrected, which I think is right. You shouldn't be going to a court with a decision that is wrong. During the course of those discussions, there was an apparent way that the matter could be resolved and address the concerns that are articulated in the legal services directions about doing that. Now the policy reason behind that is a matter for instructors. I'm just trying to get the chronology right in terms of what I'm about to say. This was before the prospects advice, I think, that we received. But after, I think, I sought the prospects advice that we got from AGS, and obviously when that came down, there was a reference to getting more considered views in relation to the lawfulness of the program. All of those options were open.
Okay. So what ultimately happened, of course, is that AGS provided a draft prospects advice on the 27th of March 2019.
Yep, that was on instructions from the Secretary.
And ultimately, and beyond that, a legal advice was obtained from the Solicitor General.
Yes.
Which decisively dealt with the issue.
I believe it did. But even after that opinion was handed down, there was still, within government, questions.
We'll come to that shortly. But ultimately, that's what led to the end of the scheme.
Yes, that's right.
And the concessions made by the Commonwealth in
the Mater, yes.
And Masterton.
Yes.
Now, it wasn't until this Royal Commission that opinion of the Solicitor General or that draft advice of the Australian Government Solicitor became public knowledge. Correct?
I believe that's correct.
And so it wasn't, but for this Royal Commission, the precise basis of the unlawfulness of the scheme and what effectively brought it to an end would not have been public knowledge, correct?
That's correct. There was a decision by consent, though, in Amato.
Sure.
Yep.
But it doesn't articulate the legal issue to the same extent as the Solicitor General's opinion does it?
No, it doesn't. It doesn't go into all of those things that are in the opinion. It doesn't answer the direct questions that were put to the Solicitor General. I agree with that. See, I suggest that one reason why there might be a desire to avoid a determination and instead, that is a determination of a court, and instead get an opinion of the Solicitor General to resolve the issue is to ensure that there is no public revelation of the extent of the unlawfulness that was involved in the program. I'm not sure if I agree with that. I think that there was a public revelation by way of the decision by consent. I mean, sure, the decision by consent didn't examine that issue of inference that we've just been discussing, but I think it made it pretty clear that there was invalidity at the heart of the program that was being administered. So I'm not sure if I agree with that proposition, Mr. Scott. All right. But again, that wasn't for me. Those sort of concerns about reputational damage and what have you were assessments that needed to be made by instructors, I think. Okay. I'm going to ask that the witness be shown a different document. This is in volume 1 of your large bundle, Mr. Ffrench, tab 13, I believe. Exhibit 5365, doc ID CTH.3035.0017.0616. Thank you. Yes, I have that. All right. Have you had a chance to review this document in your preparation for today, Mr. Ffrench? I have seen it before, yes. Agree with me that it is an email chain in February 2019 concerning a draft report of the Commonwealth Ombudsman. Yes. An implementation report, yes. Yes.
And when you say implementation report, that is its report of its investigation into the implementation of its recommendations from its 2017.
That's my understanding, yes.
Thank you. And you agree with me that you received that email
Yes.
ultimately on the 22nd of February 2019 and the draft report?
Yes.
Now, can the witness please be shown, and this should be behind your tab 14, Mr. Ffrench. Exhibit 5366, doc ID CTH.3035.0017.0618.
Yes.
You agree with me that's the draft report we've been discussing?
Yes.
All right. If you could please, the screen be turned to page 27 of the document. You got that page 27 in front of you, Mr. Ffrench?
I do.
That should be headed comment on legality.
Yes.
It opens, we note the question around the legality of the EIC system is still a matter of public debate. In particular, some observers,
Yes, I see that.
refers to the Carney and Hanks articles,
Yes.
have argued that the application of averaging ATO reported income to arrive at the calculation of a fortnightly debt is legally flawed. DHS has strenuously refuted this view.
That's correct. And that's a correct statement too.
Sorry, what's a correct statement?
DHS has strenuously refuted this view.
Yes, thank you. And then it went on to say, while we did not focus on this issue in our original report, we did turn our mind to it during the original investigation. We concluded that the complex question of the system's legality could only be resolved with certainty by a court, with the benefit of fully argued legal submissions on the facts of an individual case. We considered it would be unhelpful to speculate in a public report about what the Federal or High Court might decide on the untested and complex questions of legality raised by the EIC. We note that there is now a matter before the Federal Court where these issues may be considered.
Yes.
And that's a reference to the then current Masterton proceedings.
Yes, that's what I understand it to be.
Yep.
It is.
Okay. And then paragraph 4.5 recommended that advice from external lawyers be
Yes.
obtained and cited to reassure the public that the department had sought advice on the issue of legality.
Yes.
Now, if we go then, please, to tab 15, Mr. Ffrench, exhibit 5367, doc ID CTH.3004.001.4092.
Yes, I see that.
You recall this email,
Yes, I do.
22nd of February 2019,
Yes, I do.
and you see that it's a reference to a meeting brief for the Secretary for her meeting with the Commonwealth Ombudsman?
Yes, this was, yes, the Friday, the week before that meeting.
Yes, and it says that the meeting brief requires updating to include input on matters relating to that section of the report, the draft report we just discussed.
It does, by the following Monday,
Sorry?
by 2 p.m. on Monday the 25th.
Thank you. Then could the witness, this is your tab 16, Mr. Ffrench, could the witness be shown exhibit 5368, doc ID CTH.3007.0011.2505.
Yes.
Now you recognise that email chain, Mr. Ffrench?
Yes, I do.
It concludes with an email from Ms. Mussolino to yourself on the 24th of February 2019,
Yes.
referring to an earlier email from you to her on the 22nd of February 2019,
Yes.
stating, FYI, this is where we're going with this.
Yes.
That is with the secretary's brief that had been requested?
Yes.
Can we take it that and you can see in Ms Mussolino's email to you says, see my additions, let's discuss Monday?
Yep.
And those additions, are those the words that are in capitals and red?
I believe so. Yes, I think so.
Okay. And then that is in your email to Patrick Collins, that's at the bottom of the page on the 22nd of February 2019?
Yes.
Okay. And the balance of those words that are in the blue text, they're your words?
They're words that Mr. Collins and I worked through together based on the department's position at the time, yes.
Okay. Who's Mr. Collins?
He was the acting branch head. He followed, Mr. Stipniks, I think, left the department in February.
Okay. And these were words to be inserted, in contemplation of being inserted into the secretary's brief, correct?
They were words to be included in Michelle Kelly's meeting brief to the secretary, yes.
Okay. All right. Can I just ask that email from yourself to Mr. Collins dated the 22nd of February be called out, particularly up to and including the second bullet point? Now, the second bullet point in that email states this: the legality of procedures at the heart of the EIC system is not uncertain, nor does the department accept that EIC raises concerns about the legality of programs of automation. See that?
I do.
Those words, the legality of procedures at the heart of the EIC system is not uncertain. Do you accept those words are not true?
I accept that those words represented the department's position, but I also accept that those words are plainly not true. I regret clearing those words. The legality at the heart of the EIC system, in my view, was uncertain. This is a positional statement with respect to what the department was saying. If I had my time again, I think I would temper some of those words. I'd also make it very clear that what I was doing was describing the department's position.
Because what I suggest was being represented by the totality of these words in this email was that the department was confident in the legality of the program.
We referred to the draft report before where the Ombudsman noted that the department was strenuously refuting any suggestions otherwise. That was plainly the case for 2 years prior to this.
When, contrary to that representation, within the department, at least from your point of view, the department's position was manifestly weak.
I didn't say manifestly. I said that I didn't. Yes, I did believe that the department's position was weak.
Now, the object that was sought to be achieved ultimately by the department was to persuade the Ombudsman to remove the section commenting on legality in the report, correct?
I understood that to be the objective.
And the department secured that objective?
The department did.
That is, that section commenting of legality was removed, wasn't it?
It was.
Your volume 1, Mr. Ffrench, tab 30. It's doc ID CTH.3003. I think it's 0001.0708. Exhibit number 5379.
Yes.
And do you see that's an email chain culminating with an email from Ms Leon, the then Secretary, on the 8th of March 2019 to yourself?
Yes.
Forwarding an email from her to the then Ombudsman on the 8th of March 2019?
That's right.
Now, if we call out the paragraph in the middle of that email commencing with the words in relation to 4.5 of the draft implementation report, to see the words there in the second sentence of that paragraph, the department has consistently maintained that the legal basis for the EIC is sound.
I think that's a statement of fact.
Yep. And then in point 2 under that paragraph, the position is stated, the second sentence, we have not, so I'll read it, point 2 in full. I should note that the department does advocate for amendment of legislation to the relevant policy agenda where it considers this would clarify legislation. We have not done so in this case because our position is and remains that the legal position in relation to the program is not uncertain.
Yes.
That's a clear representation, isn't it, that by Ms Leon, that the department was confident in its legal position?
Yes.
Do you agree that is consistent with the words from the previous email I showed you?
There was a draft version of that email that was provided to Ms Mussolino and I believe to the Chief Operating Officer. I'm not sure if those words were in the draft that I provided or if they were added, but are we able to see that?
We'll have to look for that, Mr Ffrench.
I believe there is a reference to that in my statement. I can give you.
Told there's a reference at footnote 69.
Well, while that's being brought up, Mr Ffrench, do you agree that the representation in this email from the Secretary did not reflect what you knew about the strength of the legal position of the department?
I agree with that, but it reflected the department's position. As it says, our position is and remains that the legal position in relation to the program is not uncertain.
Okay. Well, Ms Leon forwarded her email to you.
Yes.
Did you respond to her email to inform her that her email to the Ombudsman did not accurately reflect the strength of the department's legal position?
No, I didn't. But at the same time as this, I actually sought instructions from the Secretary to obtain what became the prospects advice that we're talking about. This email was sent after that meeting. I thought it had been sent before that meeting, incidentally, where we discussed the department's position and the Masterton application. So, no, I didn't talk to her specifically about this, but I knew that at the time she was aware that there were questions being raised by the Masterton application that had substance.
Well, is that an explanation for why you did not advise her that she had overstated the strength of the department's legal position in her email to the Ombudsman?
Look, the department had been stating its position with respect to the legality of this scheme in very uncertain terminology for quite some time. I didn't challenge her on this particular construction of it. What I was doing at the time was seeking instructions to get some external legal advice that could move us away from that entrenched position. So no, I did not go back to the Secretary and say, your statement here about the department's position being, let me just see what I said, not uncertain, was overstating things. Where would I begin with that kind of conversation? The department had been overstating its position now by that time. for 2 years, if not longer. But no, I didn't do that.
Do you agree that the appropriate course for a Department of the Commonwealth to take in relation to an Ombudsman investigation is to provide whatever assistance it can to that investigation?
Yes.
Do you think overstating the strength of the department's position in this email, given the context, is consistent with assisting the Ombudsman?
I think the department was making it very clear what its position was. The Ombudsman was aware that the department was strenuously defending the scheme. It had been doing so for 2 years. Is that of assistance? Is it of assistance for a department to let the Ombudsman know what its position is?
Well, put it another way, is it of assistance to the Ombudsman to overstate what the department knew was the strength of its legal position?
I don't think the department... I think people in the department sincerely believed that Robodebt was lawful. I don't know whether that's the case with the Secretary. And I say that because when the advice on prospects was handed down and I spoke about it in a meeting, there were audible gasps in the room when I said that the department's prospects on the basis of this advice were poor. So I'm not sure that... I think the department was overstating its position. But I think there were people who actually believed in that position.
Okay, so the advice on prospects was handed down. That's a reference to the AGS.
Yes, that's right.
Draft advice on the 27th of March 2019.
That's right.
Who was in the room that were giving those gasps that you mentioned?
So I had a meeting with the chief operator. We'd have a weekly stand-up. This happens quite commonly in bureaucracies. My superior would have her direct reports in the room. We would talk about the issues that have been raised by the executive. Those messages would then be cascaded down to others in the teams that those individuals were responsible for. At the same time, we would talk about hot issues. And I would talk about Robodebt, unsurprisingly. And I spoke about the prospects advice that we received in the Masterton matter and the effect of that advice.
So who was present in the room at the time?
All of the direct reports to Roxanne Kelly, who was the Chief Operating Officer. I think her Executive Officer would have been in the room as well.
Okay, what about...
And maybe her Executive Assistant.
Okay. Well, did you communicate to Ms. Leon your views as to the strength of the department's legal position at any stage up to this email that we've been discussing?
So immediately, I had a meeting with Ms. Leon around about... I have a chronology here, I might just refer to it.
Is that the chronology in your statement?
It's based on the dates in my statement.
So can you just for the record, can you articulate what you've got there, Mr. Ffrench?
This is a chronology based on the contents of my statement that has been prepared with the assistance of the Australian Government Solicitor.
Okay. And is it just a reflection of what's in your statement?
Yes, it is.
Okay, thank you. If you could continue, please.
On the 6th of March, I believe, 7th of March. So I attended a meeting with the Secretary. I can give you paragraph references to demonstrate the point. It was at paragraph 102 and 138 in my statement.
102 and 138?
Yes.
Okay, and 130. So refer to a meeting on the 7th of March. Okay, and you say on the 7th of March, this is paragraph 138 of your statement, you say you attended a briefing with Secretary Leon, Ms Mussolino and Ms Kelly to discuss the Masterton matter. In that meeting, I raised the desirability of obtaining further advice concerning the Commonwealth's position and received the Secretary's instructions to do so.
Yes, that's right.
Okay, so...
So by that time we'd received, I think on the 7th of March as well actually, AGS advice that it was along the lines of the application had substance or the Commonwealth's position was not without risk, but it wasn't fully articulated, and I didn't think that addressed the issues that needed to be addressed to properly inform the department's position on the lawfulness of Robodebt. So I actually actively sought those instructions to get that advice.
Okay, so during that meeting, did you articulate what you considered to be the strength or lack thereof of the department's legal position?
I did say that the department's position was uncertain, and I can't remember how far down that path I went, but I did urge the Secretary, that's probably putting it too strongly. I did strongly put to the Secretary that the department should get further and more considered external legal advice on its prospects.
Mr. Scott, it's just past the lunch hour. We are not moving so very quickly. Should we come back at 2?
Yes, Commissioner.
All right, we'll adjourn till 2.
All rise. The Commission stands adjourned until 2 p.m. The Royal Commission is now in session. Please be seated.
Yes, Mr. Scott.
Thank you, Commissioner. I'm just trying to find a document, Mr. Ffrench. It's doc ID CTH.2001.0013.5897, tab 56 of your first volume, and it's, I think, Exhibit 3403.
I'm sorry, what tab was it, sir?
56, I think.
Your tab 56, but I don't think the correct document is on the screen. Should be CTH.2001. 0013.5897,
Yes, I have that.
and it's Exhibit 5403. Now, to contextualise what I'm about to ask you about this document, I'm going to ask you some preparatory questions. Okay, Mr. Ffrench?
Sure. Yes.
Now, in relation to the Masterton matter, is this right, that a view was formed relatively early in the proceedings that there had been errors in the calculation of the debt,
Yes.
in particular some double counting,
Yes.
and then a view was formed that there be a recalculation of whatever debt was owed?
That's right. That was strong AGS advice. Consistent.
Yes. And what ultimately was concluded at a meeting on the 1st of April 2019, which is the date after 2 days prior to the email that's on the screen there, at which you were present and Miss Leon was present,
Yes.
was that the recalculation be done with reference to material in the affidavit
Yes.
filed in support of Ms Masterton's application.
Yes.
Now, can you assist us, from your recollection, what was in the affidavit that was thought could assist the recalculation?
So I recall that in a conference with Ms Mussolino and Mr Ensby and myself, Mr Ensby suggested that the affidavit would amount to additional material that may be able to be relied upon consistent with the department's policy and procedure.
Okay. And just to further contextualise it, prior to that, is this right? The Commonwealth through AGS notified the applicant's lawyers of the intention to carry out the recalculation.
I understand that the Commonwealth's lawyers did.
And invited Miss Masterton to provide further evidence to enable the recalculation to occur?
Yes. Which was a request, according to this scheme anyway, would have been made earlier, but yes.
Okay. And that invitation was rejected?
Yes, that's right.
Okay, and so then consideration was given to how the recalculation could be undertaken.
Yes.
And of course, in circumstances where by the date of this email, the Commonwealth had the draft AGS advice regarding the unlawfulness of using averaging.
There was, yes, it was also draft prospects advice that advised the Commonwealth that it had poor prospects in the case.
Yes, and one of the aspects that was identified
Yes.
in that advice relative to prospects was the problems with the use of averaging.
Yes, that's right.
Am I right in thinking that the duplication alone wouldn't have eradicated the debt once you were adjusted for it?
Yes, that's right, Commissioner.
So you had to do something else if you wanted to get rid of it with a view to settlement?
Yes, and that could have been the use of compulsory powers. I think in Amato those powers were used.
Okay, but it wasn't used here.
No, it wasn't.
What was used here was the affidavit.
That's right.
What was in the affidavit that enabled the recalculation?
Mr Scott, I'd have to go back and look at it. But again, this was the use of the affidavit material was put to the department by our lawyer, Mr Ensby. I would have to go back and look at the record to see if there's emails or other documentation that confirms that. I can't answer that any further than what I've just said.
Did it contain any information which the department couldn't get without looking at the file and making its own inquiries?
Well, it was a solicitor's affidavit deposing that what was said was put to the solicitor. I'd have to go back and look at the affidavit and review the material to see if it had any other evidentiary weight. But it was put forward as something, this is what the advice says, it was something that was put forward in support of a recalculation.
So, just to be absolutely clear, do you have a recollection that any of the information contained in the affidavit was information that the department couldn't itself obtain either from looking at its own files or making its own inquiries?
I just can't answer that. I'd have to look at the affidavit again.
Okay.
Perhaps if you phrase your question differently, I might be able to get to the heart of what you're getting at.
Well,
What it seems to me has happened is that the department's done a recalculation on the strength of Ms Masterton's solicitor swearing to hearsay from her that as far as, to the best of her recollection, she'd declared her income properly.
Yes.
And on the strength of that, the department said, well, that's additional evidence and we will reassess the debt accordingly, looking
Yes.
at what we've got on our file.
Yes, that's right, Commissioner. And this document that's been put to me says that the program area, the business area responsible for the scheme, were of the opinion that that was permissible.
Right. And then AGS, on the basis that the department was recalculating the debt in accordance with its existing policy,
Yes.
could see no problem. But the problem with it is that it was never part of DHS's policy, was it, that where a discrepancy had been identified with ATO data and the recipient provided hearsay evidence simply to the effect they'd always declared their income properly, that no debt would be raised. You know, at the few steps in that, I'll go through it again if you like.
No, I understand what you're saying. I don't know the detail of departmental policy with respect to Robodebt at that point in time to answer that question, but I can say that this material that's been put to me says that the program area responsible for the policy was of the opinion that it was permissible.
All right, well, if DHS can produce some documented policy which said that hearsay evidence, simply to the effect that the person had always declared their income correctly, was sufficient to override the averaging process in default of other evidence, I'll be fascinated to see it. But anyway, you say you didn't know any better.
What I'm saying, Commissioner, is that the document that I have before me says that there is scope within the policy as it was to use that material.
Which document are you talking about?
It's the document Mr Scott took me to it. I can give you the...
This is the email?
Yes, the 3rd of April, Commissioner.
Well, scope. It says, well, this is not the normal approach to accepting customer advice, as we would generally be seeking verbal advice to determine precise fortnightly earnings, and this might set precedent for future customer contact. They've done the calculation. That's not really saying this is our normal policy, is it?
No, it isn't. It's saying that there's flexibility within the policy according to the program area responsible for the policy.
Where do they say there's flexibility within the policy?
Commissioner, would you want me to read it out, or can I...
Well, you can see the top line which says there's flexibility to take a customer's advice into account. There's that.
Yes.
Then they talk about the kind of customer's advice they would take into account. That would be verbal advice to determine precise fortnightly earnings. And they say that this advice, which is simply, I always declared my income properly, hearsay at best, that this might, this is not the normal approach and it might set precedent, which really doesn't sound like it's standard policy, does it?
It doesn't sound like standard practice. It does sound like the team looked at their policy and decided that within that policy there was flexibility. They had reservations potentially about it. I also note that at the end there's reference to the fact that the Deputy Secretary responsible had reviewed it as well. From my perspective at the time, we had a proposal that I believe was came from our AGS lawyer, that this affidavit material could constitute additional evidence that could be used within the policy parameters as they were. There was then material provided by the program area that said, I believe that there's flexibility within the policy as it is to use that material. That was then put to our instructors, and they gave instructions to go ahead and do the recalculation.
Well, in fact, it seems that they rather cagily said there is flexibility to adopt verbal advice. The kind of verbal advice we would accept is about fortnightly income, and this is a bit unusual, but we'll do it anyway.
I think that's right.
Okay. And as I say, I'll eat my words if somebody produces any documentary evidence of any policy that they would act on a recipient say so that they had declared their income properly. Sorry, Mr. Scott, it's an area of some exasperation to me, as you might have gleaned.
Thank you, Commissioner. Can I just put this final proposition to you in relation to the settlement of the Masterton proceedings, Mr. Ffrench?
Yes.
What do you say to this proposition that what this email reveals is the department bending over backwards to find a way to resolve the matter in order to avoid a judicial determination of the lawfulness of averaging?
I'm not sure if... How can I answer that? Was the department bending over backwards to avoid a determination? I don't know if that's the right construction. Was the department trying to resolve this without the need for a hearing? Yes, it was. Did it find additional flexibility within the policy that in most cases it would not have found? That seems to be the case from this document. But I come back to the point that the advice that was provided by the program area was that this approach was permissible. And I understand the statements that the Commissioner's made about that appearing to be unusual, and I appreciate that. But that's what I took from this document in front of me.
Okay, thank you. That document can be taken down. I'm going to ask you some questions, Mr. Ffrench, about some circumstances you describe at paragraphs 57 to 62 of your statement. Sorry, wrong paragraph, beg your pardon. 153 to 159 of your first statement.
Yes.
Now, you refer to the re-election of the Morrison government and the ending of the caretaker period on the 20th of May 2019.
Yes.
You refer at paragraph 154 to a request by Secretary Leon as part of the briefing strategy to the Minister.
Yes.
And what was that request?
That the brief... So there was when a new minister comes in, there's a briefing pack that's put together. There's lots of different material in that briefing pack.
Is that the incoming ministerial brief?
Yes.
Okay.
The Secretary had asked that as a part of that, a brief be put forward in relation to the status of the Masterton litigation, and that a verbal briefing would be given to the Minister in relation to other legal issues associated with Robodebt.
And what did... Did those other legal issues include the lawfulness of the
Yes.
averaging in the Robodebt scheme?
I'll expand upon that. So there was, it appears to be some confusion about the nature of the Secretary's request. At one point it seemed that the business area didn't think it would be necessary for me to attend a verbal briefing with the Minister. I did point out that the Secretary had requested that and asked my office staff as to how it had come about that seemed to have slipped. As a result of those queries, I was able to give a verbal briefing to the Minister. When I went to see the Minister, I took a copy of the prospects advice in Masterton and I spoke to it. And I raised with the Minister the concerns that that advice raised about the lawfulness of the Robodebt scheme and the need for the Solicitor General's opinion.
Who was present?
Ms Mussolino, the Minister, I can't recall which of his advisors were present. There is a record of the meeting taking place and my attendance, and there's probably in that record the details of those others that did attend.
Okay, so you've mentioned some of the Minister's staff, the Minister, Ms Mussolino, correct?
Yes.
What about Mr Storen?
I can't recall. Again, there would be a record somewhere, I think, of the Minister's meeting and who attended.
Okay, and how did you speak? What did you do in order to speak to the AGS advice?
I took a copy of it with me. I had it annotated, and I spoke to the Minister as plainly as I'm speaking to you right now.
And what did you say to him?
I said to him that as a result of this advice, there are difficulties with the scheme. I explained what those were, and that because of that, the department had engaged with I think by this time we had approached the Solicitor General's office and the Attorney General's department about obtaining an opinion from the Solicitor General in relation to aspects of the Robodebt scheme.
When you you told him that there were difficulties with the scheme, did you outline what those difficulties were?
I have attempted to the best of my recollection, in this statement, state what I said. I can't remember the particulars, Mr Scott, but I can say with some confidence that I attended that meeting with the preliminary advice on prospects in Masterton, and that I spoke to the Minister plainly about the difficulties.
What did he say in response?
I honestly can't recall. I think he accepted. I can't recall. I think I have referred to statements the Minister made about an opinion just being an opinion. I'm not sure if it came out of this discussion or a later discussion. I think it might have been this discussion because prior to later discussions with the Minister about the legal challenges, I had drafted a minute to him where I tried to counter that perception that I saw that it's just an opinion until we get a judicial declaration from a court. An opinion's only an opinion. I believe it might have been this meeting where he said something like that.
Okay, and you referred to a minute where you try to counter that perception.
Yes.
Can the witness please be shown Exhibit 4263, Doc ID CTH.4000.0070.2611. We have a copy for you, Mr Ffrench. If you have a look at the second paragraph or the paragraph number 2 under the heading Key Points on the first page.
Yes.
The reference to the Solgen opinion.
Yes.
And then the next page, paragraph 3. States the opinion provides that a decision maker cannot rely on ATOPAYG data.
Yes.
And then paragraph 7.
Yes.
Words, whilst noting that the opinion does not amount to a judicial declaration of law.
Yes.
Is this the minute you drafted that you just referred to?
Yes.
Thank you. All right. That can be taken down. Now, can we bring up on the screen Doc ID CTH.2013.0012.5378? And I believe it has a, does it have an exhibit number? It's already been exhibited. Okay, already has an exhibit number, it's 5010. I understand a copy's been provided to you, Mr Ffrench.
I'm not sure what document you're referring to. Is it in this bundle of material or?
It's a hard copy of an email. Perhaps if we that could be provided to the witness?
Oh, yes, I do have that, sorry. My apologies.
So, Mr. Ffrench, this is an email from yourself to Ms. Leon on the 17th of November 2019.
Yep, Sunday morning.
Yes. And the context, Mr. Ffrench, is that the Solicitor General had given his opinion on the 24th of September 2019.
Yes,
So by that stage, it had been in the possession of the Commonwealth for a couple of months.
not quite 2 months. It was probably, I think in this document, I counted the number of weeks. It wasn't a couple of months, but I won't quibble.
Okay, and we call out the section in the first paragraph. It's addressed to the Secretary, Ms. Leon. You have asked for advice on your obligations concerning the administration of the Income Compliance Program, following the provision of the opinion of the Solicitor General and the confirmation of that opinion by the Attorney General. If we pause there, those words, confirmation of that opinion by the Attorney General, what's that a reference to?
That's a reference to the Attorney General's endorsement of the Solicitor General's opinion on the 12th of November. I refer to it in that document.
Yep. That's where you overheard the Attorney General say to Mr. Robert, it's right, mate.
That's right.
Yep.
Just to give some context to that, remember there was a view that an opinion's just an opinion. I think once that endorsement was given, it was clear within government that the position that it adopted needed to change and that the Solicitor General's opinion was right.
Okay, and that endorsement by the Attorney General on the 12th of November, that was outside
That's right.
an Expenditure Review Committee?
That's
meeting?
right.
Okay. And it says, the settled legal position is now that reliance on apportioned ATO PAYG data alone does not provide a sound basis in law upon which to raise a social security debt. See that?
Yeah.
And then you say, specifically, you've asked how much flexibility you have or do not have and how and when you take further action.
Yes. Yes, I do. And throughout that document, I've said things along the lines of the prime consideration must be to minimise harm.
Yeah. And you, on the second page of that email, under the heading, your obligations to take appropriate action following the settled legal position,
Yes.
discusses obligations under the PGPA Act.
Yes.
And you refer to what a reasonable person acting in good faith and with care and diligence would do.
Yes.
That is, weigh before acting the following factors: the foreseeable risk of harm their actions create versus the utility of the actions,
Yes.
the extent of the risk so created, agree?
Yes.
The likelihood that the risk will actually cause harm to others,
Yes.
any alternatives of lesser risk,
Yes.
and the cost of those alternatives. And if we go to the second last paragraph on that same page, the last sentence, the words, these risks will include the budgetary impact of changes and the impact on the recovery of other debts that have not been solely raised on the basis of apportioned ATO PAYG data. See that?
Along with a large number of other factors, I thought that was appropriate for the Secretary to consider. Following this email, the next day she paused the program, incidentally. And I did speak to her after giving her this email and emphasised again that the prime consideration must be to avoid harm.
Yep. And then on the next page, second last paragraph, you state, in this regard, there is no key date for any particular administrative action following receipt of the opinion or the settled legal position, nor is there any particular administrative action that you are required to take. However, you are obliged to make informed decisions that weigh and manage competing risks and to do so as promptly as possible in the circumstances.
Yes.
You go on, the establishment of an appropriately targeted and research project team to assist the risks associated with the program in light of the settled legal position and to develop strategies, including staged or incremental strategies to address those risks as appropriate administrative action in the circumstances.
Mm-hmm.
See that?
Yep.
And then you conclude, when you are satisfied that appropriate care and diligence has been applied in developing the department's planned actions and the department is ready to give effect to its planning, you should instruct it to do so.
Yes. And it goes on to say, any delay without good reason will increase the risk that you are perceived as having failed to meet your legal obligations.
All right. So when did those instructions from the Secretary to give effect to her planning get given?
I don't know. What I was giving to the Secretary here is information that was relevant to her determination as to what to do about this scheme. By this stage, it was plain something had to be done. Now, you haven't referred yet to the minute that I gave to the Secretary where I outlined her obligations and her explicit legal risk. That was behind this document. What the Secretary was asking me here is, what flexibility do I have? And that could, to determine what to do, she had to take into account a large number of things. It wasn't for me to exclude anything. It was a matter for the Secretary of the department to make that decision. And she did the next day.
The next day?
The next day.
What decision's that?
That was to suspend the scheme.
Okay. All right.
And that was after I spoke to her. Okay. That Sunday morning. So I was actually in Nowra visiting my mother who had broken a hip, and I was called out of the hospital to have a conversation with the Secretary that Sunday morning about these issues. And I spoke to her plainly about the risk and the obligation to avoid harm. And as a result, I think in some small part of that conversation and this document and the earlier minute and the other conversations I had with the Secretary and others, the scheme was closed the next day. Now, I don't want to take complete responsibility for that by any means, but I think I played a small part in it.
Okay. And the minute that you're referring to is the minute we just looked at a short while ago today?
No, it isn't. That's the minute to the Minister. There was a minute to the Secretary as well, detailing her own personal legal risk.
Okay.
But to be clear, there's not a great deal of difference between those 2 minutes. The minute to the Minister referred to the Secretary's legal risk, and the minute to the Secretary largely reflected that.
Okay. And that included, for example, the...
To minimise harm, yes.
Yes. And the issues about misfeasance in public office?
Yes, it did.
And the issues about the Secretary's obligations?
Under the PGPA Act, as the agency head under the Public Service Act, yes.
Thank you. Commissioner, that's the witness's evidence.
Do you remember at your meeting with the Minister back in July 2019, his explaining to you the problems of averaging and how it could lead to calculation of wrong debts?
I'm sorry, Commissioner, my explaining to the Minister...
No, the Minister explaining to you.
I don't recall the Minister explaining to me anything about his understanding of the difficulties with averaging. I do, as I said before, I recall talking to him about the advice that we'd been given, and in that, obviously, the most consequential part of that advice is about the use of PAYG data and averaging.
All right.
So I spoke to him about that. I don't recall him making those kind of statements in response.
Did he at that time indicate any understanding of the problems of averaging that you recall?
I don't recall him disagreeing with what I put to him, but I don't recall the precise comments that he made, aside from that noteworthy and memorable comment about an opinion just being an opinion. I can't recall the detail of the rest of the conversation.
All right, thank you.
Commissioner, following on from that, can I just ask a couple more questions of the witness, which I omitted to ask earlier? Did he, that is the Minister during that meeting, ask whether there was any existing legal advice on the issue of ATO averaged data?
No,
Okay.
I don't recall him asking that question.
Okay. And did he express any words to you indicating a decision by him? Sorry, I'll withdraw that. Did he express any words indicating a decision by him to obtain external legal advice?
No.
Thank you.
Yes, Ms Hogan-Doran.
Commissioner, I'm just going to deal with a matter that completes the record in terms of some earlier evidence that Mr Ffrench gave in respect of a draft email that he had prepared for the Secretary at an earlier period of time. Commonwealth had informed the Commission this email was referred to in his statement at 69. It is, but it's the covering email that's referred to only in the statement, not the actual body of the document. I want to show him the document, have him identify it, and then it can be tendered.
One for him, one for me, I think, isn't it? No.
Have you got another set? Yep.
Take them down.
I can provide another copy for you.
If you've got one spare, I'll take it, but it's not critical.
I believe Councillor Sisting has it,
Thank you.
or has them. Mr. Ffrench, could I just have you look at the first document, which is CTH.3004.0011.6397.
Yes,
It's a draft email to send to the Ombudsman-EIC processes.
yes,
And that's one of the documents that's referred to in footnote 69. Could you just look at the document attached,
yes,
which is CTH.3004.0011.6400. Do you identify that as the draft for the Secretary? All right, thank you. So just on that first page, 6400, there's a typed document going over half a page on the next page, and then at 6398, which must be out of order, is an annotated document which appears to be an extract from the draft Ombudsman report, heading Part 4, Comment on Legality. Do you have that?
yes, I do.
Whose writing is that?
That's the Secretary's writing.
All right. And just looking at the next page, 6399, whose handwriting is that?
That's the Secretary. Yes, that's the Secretary's writing.
All right. I'll just have it confirmed, the order in relation to that document. I'll just ask you to look at the next document, which is CTH.3004.0011.6338.
Yes,
And this is for clearance, Secretary's email to Michael Manthorpe.
yes,
All right, and attached to that is a document, CTH.3004.0011.6339,
yes,
and you see that that is a typed document going over to the following page.
yes.
Am I right in thinking that is a shorter version than the one that we just looked at?
That's my draft. Sorry, I shouldn't say my draft. That's the draft of the Legal Services Division. There's differences between the two because, as you can see from this email, Ms. Kelly and Ms. Mussolino had input and clearance into the final version, which was then provided to the Secretary in the first suite of documents that you took to me.
All right, and just before I come back to that, the next document at CTH.3004.0011.6341 and over to the next page,
Yes,
6342. Is that the same document that you saw before and identified as being an extract from the draft Ombudsman reports with Secretary Leon's handwritten annotation?
yes, it is.
All right. Commissioner, all I seek to do is just identify those. I don't know if that raises any matters or questions that Mr. Scott wants to address.
Should they be made exhibits now?
I believe they already are exhibits,
They
Commissioner.
are, okay, with the handwriting.
Commissioner, I'm not sure. We'll have it checked and we'll have it confirmed.
If not, let me know and we'll make them exhibits.
Indeed.
The significance of those two documents, to my mind, is that the initial draft did not contain the words "is not uncertain," which was put to me by Mr. Scott before.
Right, thank you.
No further questions, Commissioner.
Thanks. Do you want Mr. Ffrench excused?
Yes, please, Commissioner.
Thanks, Mr. Ffrench. You're excused.
Thank you, Commissioner.
Okay. Who's next, Mr. Scott?
Commissioner, the some documents are just being moved, but I next call Jason Ryman.
I think Mr Ryman probably wasn't excused last time. Do you remember? Do you remember, Ms Hogan-Doran? You're usually the repository of wisdom on this.
No, he
stuff.
was not excused.
Okay, thank you. Take a seat, thanks, Mr Ryman. You'll remember you're still on, whether it was an oath or an affirmation, it still binds you. Thanks.
Yep.
Yes, Mr Scott.
Thank you, Commissioner. Now, Mr Ryman, since you last gave evidence on the 8th of November 2022, you provided a supplementary statement dated the 24th of November 2022.
Yes.
Are the contents of that statement true and correct to the best of your knowledge and belief?
Yes.
Thank you. I'm going to ask you some questions about some documents which I understand might be in those two folders that have the maroon colours on them towards your far right. Can you see those?
Yes.
And I'll indicate the tab number so you can go to them as you go. So if you want to grab them now so you can go to them in the course of our discussion. The first document I want to ask you about is behind tab 7, which must be in volume 1 of that folder, those two folders. It's Exhibit 5506, Doc ID CTH.2004.0001.3468_R.
Yes.
Now, have you had an opportunity to review this document in preparation for your evidence today?
Yes, I have.
Okay. Now, you agree with me it's a chain of emails from October 2014?
Yes, I do.
Okay. And it starts with an email from Mr Britton, dated the 27th of October 2014, referring to the attached containing a preliminary analysis of the current pool of PAYG matches for discussion this afternoon. See that?
Yes, I do.
And then the response from Mr Withnell. Sorry, before we do that, you see Mr Britton's email is addressed to Alana and Murray.
Yes.
Can you assist us as to who Alana and Murray are?
I would say that would be Murray Kimber at DSS. I'm not sure about Alana.
Okay, and given it's referring to the attached being for discussion that afternoon, do you agree that it's an attachment for the purpose of discussion in a meeting involving Mr Kimber of DSS?
Yes.
Okay. The response from Mr Withnell, also on the 27th of October, is this: why has this gone to DSS? I haven't seen it. We have no authority even for the measure as yet, and now we have given away control of it. Do you see that?
I do.
Do you have any recollection of being aware of Mr Withnell's reaction to the provision of this information to DSS?
No, I don't.
Okay. Do you have any recollection that the purpose of the meeting was to discuss the proposal that ultimately became Robodebt?
No, I don't.
Okay.
Can you shed any light on why Mr Withnell, Mr Withnell would have been so annoyed at the information being given away to DSS already?
I'm really not sure, Commissioner. I wasn't involved in this email chain.
Okay. Do you recall any involvement in the meeting on the 27th of October 2014?
No,
Or being made aware of what was discussed at that meeting?
no.
Okay.
And when you say you don't recall any involvement, do we assume that you weren't involved or?
Yeah, I wasn't involved in that meeting. I think it was a very early meeting.
Okay.
Sorry, did you say it was a very early meeting? When did you start getting involved in the working up of this proposal? Do you remember?
I believe the first I recall is, and whether it's prior to this, I think it's in my statement, Commissioner.
I know that you did that minute for Mr Britton, but
Yes.
at this stage of the game where it's starting to be talked about as an actual budget type measure proposal?
I believe so, and I'm not quite sure of the exact date. It's in my statement. But I was made aware by Mr Britton at some point in October, and I'm not sure whether it's prior to this meeting or after this meeting, that he had met with DSS to discuss potential budget measures. And he subsequently then set a meeting with myself and I believe Ben Lumley to talk about the outcome of that meeting.
What did you see as your role in all of this? What was your part that you had to play?
In the
In the development of that measure, I guess. At this stage, what do they want you for?
At that stage, I think Scott was talking to a number of people in the branch and he was asking me to probably support him in bringing forward some thinking around some possible budget measures.
So what was your area of strength?
My team was called the Policy, Strategy and Business Solutions, and we were always looking at different ways by which we could do things.
From any particular angle or?
Pardon?
From any particular angle?
At that time, we were actually looking at how do we introduce new ways to reduce customer debt? How do we go about getting to customers, talking to customers early so they're not incurring debts for a longer period because we've failed to act early. Now that's very contradictory to, I would say, the OCI or the PAYG measure.
In what sense? What are you saying?
Because that measure was more about going backwards to look at historical, risks and, address historical risks rather than looking at how do we engage customers early so they don't get into debt in the first place.
Yes, okay, thank you.
Mr Ryman, do you have a memory that DSS were effectively excluded from the early development of the proposal in late 2014 and January up to mid-January 2015?
No, I don't.
Okay. Do you recall an early draft of a new policy proposal being developed in December 2014?
Yes, I do.
Okay. Do you recall someone called Miss Hodgson being involved in that?
Yes, I do. Miss Hodgson was a member of my team.
Okay. Tennille Collins?
Yes.
Okay. Do you recall having a conversation with Miss Collins in December 2014 in which she expressed surprise to you that the proposal was being considered for and developed into a new policy proposal?
I don't expressly recall the conversation, but I do recall we had discussions about this being put forward as a measure, a potential measure.
Right.
And I think we're probably both of the view that we had not done enough work at that stage.
And Miss, for that reason, that when you say done enough work at that stage, not decided on a final process regarding the digital intervention process, or tested that process with policy and legal stakeholders?
No. So
So are you agreeing with that, what I said?
Yes, I am. I was just going to add to it, Mr. Council.
Please do.
At hearing block 1, you showed me in the document where I put forward to Scott and got an agreement around essentially what our work plan for Tennille's team was going to be in 2014 and 15. By that stage, when you're getting towards sort of, when they're starting to talk about this as a possible budget measure, we had not done we hadn't progressed that thinking very far.
Okay. So would I be right in understanding that you agreed with Ms Collins' reservations about taking the matter forward at that stage?
Yes.
Okay.
What was the thinking behind drawing up a draft NPP at that stage in late 2014?
I would have been asked to start to get that prepared.
Right, but by whom and what were they wanting to achieve, do you think?
So I would have been asked by Scott Britton to start to bring together the budgetary documentation.
Where did all that come from? Because it seems to have sprung up in around October, November.
Yep.
Had there been any build-up to it, or?
The only build-up that I can recall, Commissioner, is the discussions that Scott had and Mark had had with DSS, and then the subsequent discussions Scott had with myself and Ben Lumley about wanting to bring forward, ideas for DSS.
Do you recall expressing to Ms Collins frustration that others were putting this forward?
Frustration, I'm not sure. I couldn't say that. I'm not sure about that, sorry, Councillor.
Well, did you feel like there was pressure from others to bring it forward when it wasn't ready to be brought forward?
Yes.
From who?
I'd probably, if I could just go back to your previous question, I wouldn't say, I'm not sure about pressure. I would probably more reflect on we hadn't done like we would normally do the preliminary work to be able to sort of bring together something that we would have significant confidence in.
Yes. But notwithstanding that, there were others who wanted it to be brought forward.
Yes.
Who were they?
Well, I was working to Scott Britton, so that's, Scott was sort of providing me instructions.
And did he express, notwithstanding your reservations, a keenness for the matter to be proposal to be brought forward?
Yeah, he expressed a keenness to, I wouldn't say keenness, but this is what we're bringing with, this is what we're going to look to bring forward.
Right. Did you make your reservations known to him?
I don't recall if I made my reservations to him at that point. I certainly made my reservations clear to him in subsequent budget measures that flowed off this.
What sort of year are you talking about?
I'll talk about, this was going through in the 15-16 budget. I think there was other measures that went through in the 15-16 by EFO, and then the following budget. And I did express reservations that, that we're putting forward measures to extend on something that actually hadn't even been built or tested.
Okay.
And you spoke about you hadn't done the preliminary work you would normally have done. What kind of thing would you have anticipated would have been done before you got to the stage of talking about budget measures?
Because it was such a new idea, and I expressed there's a couple of concepts attached to that. One was the online solution, or a way by which customers could engage with us online. We hadn't really scoped any of that thinking out besides a broader concept of, we want customers to be able to engage with us online, but not got to a point of really mapping out what that would look like. And similarly, when I previously talked about the trusted data assessments, we were very much in preliminary stages, and that piece of work was looking at direct application of, other data sources where you can think about having a direct application of that, notwithstanding not even going, which would mean you wouldn't even go to the customer. And it was just a concept, Commissioner. And we were just sort of, in really preliminary research stages at that point.
Of applying the ATO data straight to a customer?
Or we're researching a lot of different data sources, PAYG being one of them.
So in the ordinary course, but for those intervening events, would you ordinarily have tested the platform before it was rolled out?
Well, it'd be difficult to test the platform because you need to get funding for the platform, but we would have, done some level of testing. We would have worked out, okay, what is it we actually want to, what's the real specifications we're talking about? Why do we want customers to engage with us online? We would be thinking about how they would do that. We would be thinking about a whole range of things, not just, a lot of step further than just we want a digital solution.
Some kind of pilot?
Possibly a pilot. I mean, a pilot would be difficult because you'd actually need the technical solution, but we would have thought about ways that we could do some testing or some customer engagement to think about, and that was a lot of Tennille's team's role, was about, trialling different things and testing different things, engaging with customers to get a sense of, is there something that they think would be beneficial?
What about legal advice?
At that point? No, we hadn't proceeded to legal advice in October.
Oh, I know. I understand that.
Yep.
I'm seeking to ascertain if it hadn't have been brought forward as quickly as it had, would you have in the ordinary course obtained legal advice at that stage?
Oh, we would have, as if we were doing that as part of the, we thought there was a need for legal advice, yes, we would have.
What about greater involvement of DSS?
With DSS, in terms of researching and testing concepts, I mean, we always had regular engagement with DSS, and I think we would have sort of made them aware of what we're doing, and I believe Scott even shared with DSS the work plan that we spoke to in hearing block 1. And when we were testing things, we would generally keep DSS informed and saying, we've got this idea, we're testing it, here's how it's looking, here's what it's doing.
Okay. Now,
Sorry.
do you recall conveying to Ms. Collins in December 2014 that you were going to talk to Mr. Withnell and argue against taking the NPP forward?
I don't recall that.
But in the event it did get brought forward, correct?
Yes. And I may have, but I don't recall.
Okay. This should be behind your tab 121, I think, Mr. Ryman, which might make it volume 2. Exhibit 5622, doc ID CTH.3030.0010.1326_R. Oh, sorry, I've given the wrong one. It should be Exhibit 5621, doc ID CTH.3030.0010.136, sorry, 1326_R.
So what's the tab, sorry?
It should be tab 121.
121 still. Thank you, but... oh.
All right, now, hopefully you've got in front of you, Mr. Ryman, another email chain. Have you had an opportunity to review this in your preparation for today?
Yes.
Okay. And the first email is from Ms. Collins on the 14th of January 2015. Ultimately, it's forwarded to you on the 15th of January 2015. See that?
Yes, I do.
And it states that it attaches what's called the updated assumptions document. And if we go to your next tab, which should be Exhibit 5622, doc ID CTH.3030.0010.1327. Do you agree with me that's the attachment to the email we just discussed?
Yes.
And it states PRYG high-level assumption savings. Can you assist us as to what this is, this document?
This document.
Yes.
So as part of a preparation for putting forward a measure, you need to determine what the savings of that may look like, or prepare information for the, I should repeat that, sorry. You need to be able to, well, for us, we need to be able to provide information to DSS to enable them to calculate what the savings would likely be generated from the measure. And so this document starts to provide details of what we think the data looks like. So the volume of potential discrepancies that has been identified, and what we think the savings would look like as a result if we would undertake all that activity.
Okay. And if we just look at the summary table, top of that first page,
Yes.
we see 3 columns, one for each financial year starting on the 2010-2011 financial year,
Yes.
and it's got a percentage of resulting debt. Is this right, that the percentage of resulting debt that's identified there is based on a comparison of, a percentage of recipients who would have a debt based on a comparison of what they've declared to Centrelink and averaged ATO data?
And based on? Yes, it would. The context that is for a lot of these, well, if I was to describe it, the way by which the data matching occurs and the data analytics team operates is they'd get when they had the data matching file on the PAYG, they'd then categorise it into risk categories. And you'll see that in, I think, page 3 of that assumptions document, the different risk categories that are reflective of how that cohort's broken down.
Before you go on, just for everyone's benefit,
Yep.
risk categories essentially is different categories of recipient categorised according to the probability that they would in fact owe a debt.
Probability that they're higher risk.
Yes.
Yeah, and I believe that the categorisation was based on different elements, including time on payment, the value of the discrepancy, things of that nature.
And according to each of those categories, the probability that recipients in each of those categories owed a debt was identified.
No, I wouldn't categorise as probability. I would say that higher risk would certainly indicate that there's a higher discrepancy between what's been declared to the agency and what was on the PAYG data. But there are circumstances where, high discrepancy cases would not result in a debt.
Right. Okay. So, but in any event, the higher the discrepancy, the higher the chance that there's a debt?
Possibly.
Possibly. Okay. And the lower the discrepancy, the lower the chance that there's a debt?
I would say probably the lower the discrepancy, the likelihood would be the lower debt. The size of it would be lower as opposed to whether their debt exists or not.
Well, as we discussed on the last occasion, just because there's a discrepancy doesn't mean there's a debt.
No, that's correct.
Yes. So the lower the discrepancy, the lower debt probability, correct?
Yeah, I would say the probability of a lower debt amount.
Right. But also the higher chance that there is no debt at all.
There would be a higher chance there's no debt at all, yes.
Yes,
But
thank you.
that's, it's a pretty marginal figure.
Okay.
Yep.
Well, to illustrate, if we go to page 3 of the document,
Yep.
and I call out the risk category table on page 3,
Yes.
on the left-hand table,
Yes.
and in particular, if we go to category, that's the third last line, PAYG 4L, that's a time on payment of less than 50% of the financial year.
That's correct.
So in other words, the recipient has received a social security payment for less than half of the financial year under consideration, correct?
Correct.
Okay. And the discrepancy between what they've declared and what the ATO has come back with is less than $5,000?
That's correct.
For that category, there's a realistic chance that the discrepancy is explained because the undeclared amount reflected in the ATO data is actually from a period that's outside of the period that the recipient's been on payment, correct?
I wouldn't agree with that. I would say it's possible. I think for me, when I look at this, we had not done any previous sort of work on these risk categories. And so, I couldn't say that definitively. Sorry, Councillor.
I don't need you to say it definitively. I'm just trying to illustrate the point about having risk categories.
Yes.
And that category of recipient, their discrepancy could easily be explained, depending on the circumstances,
Depending on the circumstance, yeah.
by the fact that they've received undeclared amounts outside the period that they've been on benefit, correct?
Yes, correct. I can see your point, yes.
Yes. And so that's the point of these risk categories, to reflect, as best can be done at a statistical level, the chance that there is a debt and that there is a significant debt, correct?
I'd agree with that, yes.
Thank you. So can we go back to the first page, and I cut you off. So where were we up to, Mr. Ryman? You're explaining the risk categories and how that impacted on the table that's at the top of the page on the heading summary.
Yeah, sorry, Council. I believe you're asking me that was that the 90%, 95%, 90% would be a result of averaging.
Oh, yes.
What I was saying, and this is what this analysis was undertaken for, is that for a high number of those risk categories, we had previously not undertaken any compliance activity. So there was no historical management information to say what the likelihood of a debt was or what the amount of that debt would be.
And I'm sorry to keep cutting you off, Mr. Ryman, but just for everyone's benefit, we're talking about historically interventions had been done at a rate of $20,000 per year.
That's right.
And these are people in the highest risk category.
The focus was on the highest risk categories, yes.
Okay. Sorry to cut you off.
Oh, yeah, that's absolutely. So to get a sense of what the potential savings look like for those other risk categories, we didn't have historical management information. So we used averaging as a way to get a sense of what the savings may look like.
Right. And did you rely solely on averaging to get that sense, or were you assisted by anything else to get an appreciation of the savings?
No, the time pressure is just averaging.
Right. I note the bullet point underneath that first table says the analysis identified that debts were increased by 13.06% when income smoothing was applied.
Yep.
Can you explain what that figure refers to?
So that figure refers to, under my understanding, where we're able to, we did have some management information, some baseline information about previous compliance activity.
And what was that information?
Where we've actually had undertaken compliance activity on those risk categories, and we knew what the average debt was for those, based on previous compliance work that had been done.
So actual review of the file?
Actual review of files.
Okay.
And then for those we also did some comparison if you were to average the amount rather than as a separate indicator, as a separate approach, what would the difference look like between what has happened where you've actually undertaken a full compliance review and what that would look like if you averaged it.
Right, and was the result that on average, based on that data set, there was a difference of 13.06% between debts based on averaging and debts based on the customer file?
Yes.
And could that be 13.6 more or 13.6% less?
I think that if that's the average, that the average is it would increase by 13%.
Right.
So there could be less, there could be more. On an average, it increases by 13%.
Right. So based on that analysis, if an assumption was made that was correct in every single case where averaging is applied, is this right, that it's likely that the debt is 13.06% more than it would be if there was the debt was based on a calculation from the file?
On an average,
Yes,
not on an individual case level.
of course.
Yep.
All right. Now,
The limitations to that, sorry, councillor, are that we could only make that comparison against a couple of the risk ratings. And so it's not complete in terms of, I wouldn't be able to tell you if that figure would be relevant for those where we didn't have the baseline data.
right, and that's because the data set that was used for that calculation that arrived at that 13.06% amount was taken from those high-risk categories
It was limited to the cases where we'd actually, had compliance activity undertaken previously.
and wasn't representative of the low-risk categories.
No.
And the thing about the Robodebt scheme was it swept up in very substantial numbers social security recipients that were in the lower risk categories, correct?
Correct.
Okay. So that 13.06% inaccuracy level was likely to be more in respect of those further customers that were caught up in the Robodebt scheme, correct?
It's possible. I couldn't say that definitively.
Okay.
It's possible.
But intuitively, you would expect that to be the case.
Intuitively, I'd agree, yes.
Yeah, thank you. So in any event, did that 13.06% figure feature in any way in the calculation that formed the basis of the assumptions for the budget measure?
I believe it did. I'm not absolutely clear, but I believe it did.
Okay. Do you know personally, do you have direct knowledge of how that figure featured?
I believe we may, and again, I believe we reduced the savings by 13%
Right.
to inform what we think the savings figures would look like.
Okay.
I believe that's what we did, because the intent wasn't, and again, in hindsight, the intent wasn't to be applying averaging on a large scale.
We'll come to that.
Yeah.
But can I just start, can we just stick with this topic for the moment?
Sure.
Would this be an accurate reflection of the basis of the calculations for the budget assumptions that became the measure adopted for the Robodebt scheme? That a nominal number of recipients that were expected to have a debt was arrived at by a process of averaging ATO data and comparing that data against amounts declared to Centrelink, adjusted by 13.06% as per this document.
That's my understanding.
Okay. Do you accept that's not a particularly reliable way of calculating how much debt might be raised in this measure?
I accept it's not a perfect way to do it, but at the time, it was identified that's the way we could do it with the time frame that we had.
Bear in mind, as at December 2014, you had reservations about the matter, that the proposal being brought forward.
Mm-hmm. Yes.
And this is a document attached to an email in January 2015.
Yes.
When you say the time frame that you had, what was that time frame?
It was quite quick, Commissioner. Again, my recollection of December 14 is that, Scott Britton wanted all the preliminary work done, to be ready by early January. I believe that was to prepare him for conversations in the new year with DSS. And, I think if you look at the time period, it really started to accelerate in terms of bringing this forward sort of from late January.
Do you know what he was aiming towards when you say discussions with DSS? What's on the other side of this timeframe?
Oh, on the other side, it would be discussions with DSS to say, you know, we've had a look at, you know, the possible savings attached to this measure. These are the number of customers we think we would be able to undertake reviews on, and we think this would be, you know, based on the assumptions we've talked about, this would be the savings we're talking about.
Where was the push coming from in DSS?
I'm not sure, Commissioner. The only insight I have to that was Scott's email to myself where he said he had met with DSS who are looking for budget measure ideas in October 2014.
Thank you.
Thank you, Commissioner. Can we go to page 8 of the document, please?
Page?
8. Now the first...
Oh, sorry, the page 8 of this document, sorry.
Yes. Now, the top of that page under the heading Summary says the following costing data is based on one intervention per customer, 866,857 customers. See that?
Yes, I do.
That was the number of interventions that was ultimately identified in the submission to Cabinet, correct?
I believe so, something around there, yeah.
Yeah. In the end, what was proposed in the submission to Cabinet was that this measure would go over 3 years.
In our initial thinking and discussions with Tennille, I believe in late 14, we were proposing that the measure commence on 1 July of 2016, I believe, rather than 1 July 2015. So we were looking at the measure purely from a point of view of commencing in 2016 with all that lead time to develop an online solution and do the necessary work in preparation for that.
And then that would go over 2 years.
Pardon? So it's a 4-year measure, but it would be commence in 16 and run over the next 3 years. But the first year from 15-16 would be development type work.
I see.
It'd give us a chance to do a lot more of the development type work.
Right. But what in the end happened was there was the manual intervention commencing in mid 2015.
Correct.
I don't have the figures in my back pocket, Mr. Ryman, but it was somewhere in the order of
100,000, yeah.
For that year, and then the measure was to go over the balance of the interventions was to occur in the following 2 financial years.
Following 2, was it following 2 or following 3? I'm not sure.
In any event,
Yeah.
the point being substantially more numbers of interventions than had occurred previously,
Yes,
than the 20,000 a year that had occurred
that's correct,
previously.
yes.
In fact, it was envisaged that in the years following the manual compliance that it would be several 100,000 interventions a year.
Yes, it ended up being that with the additional measures that came forward.
Okay. Just want to ask you, Mr. Ryman, about the second bullet point on the page that we've been discussing. It states, 35% of customers will not contact in relation to the intervention, resulting in the match data being automatically applied to their record and a subsequent automatic advice being issued to the customer. See that?
Yes.
Now, that's a reference, isn't it, to those 35% of customers not responding to the initial letter. That was effectively the first attempt, sorry, the attempted engagement with the customer under the process.
Under the process, yeah. So more than one attempt, but yes.
Okay. In any event, it was expected that 35% of customers would not respond
I'm not sure if we can say it's expected. It was an assumption that was incorporated into this document. I'm not clear where that assumption came from,
Okay.
but it was, I accept what you're saying, yes.
Are you aware that the assumption came from historical data to the effect that 35% of customers under the previous interventions did not respond to contact from the department?
No, I'm not aware it came from that, but I have nothing to disagree with you about.
In any event, this document identifies that was the assumption, that was what was going to happen.
Yes, that's correct, yeah.
And over the life of the measure, that meant an assumption that 399 customers would not respond and have their entitlements calculated using income averaging.
As the initial decision, yes.
Yes. Sorry, as the initial decision.
As the initial decision, yes.
What does that mean?
I note here that of these customers, 30% will opt to undertake a review of decision.
I see.
So what I mean by the initial decision is that where they haven't engaged, we've issued a debt notice on the basis of averaging, and the assumption was 30% of those would re-engage the agency or had to have a review of that decision.
By way of review, what are you referring to?
Pardon?
What do you mean by
Review. So they'll exercise their right of review.
where?
Either through a authorised review officer. Well, generally it would be through an authorised review officer. I'm not sure, actually, I'm not sure at this stage, but yes, there it is. Sorry. We're also thinking at this stage about a reassessment process prior to going to an authorised review officer.
Okay, what is the reassessment process?
So there's a provision in the Act that allows for a secretary-initiated review, which is a step before having to go to a formal authorised review. And we look to introduce this on a larger scale, which is a more simplified way by which a customer can seek to review and update their details and circumstances before they would need to go to an authorised review. Okay. And so it was a secretary-initiated review, but we called it reassessment. It's not something that had been widely used in compliance, but we were looking at bringing that as a step to the process to make it easy if customers wanted to try and provide more opportunity for the customers to engage with us.
And in that process, was it assumed that for the debt to be varied, the customer would have to provide evidence to demonstrate it was inaccurate?
No.
What was envisaged?
What was envisaged is that they would just engage with us, similar to the first engagement that we were asking them to. And so that wasn't a requirement to provide evidence. You could provide, here's what I think the breakdown looks like of my earnings. So we'd accept, for example, in the manual first year, we'd accept verbal. And when we went to the online environment, they could just re-enter the online platform and input the information.
I see. So just so we're clear, what was envisaged was that after the subsequent advice being issued to the customer, there was an expectation that 30% of those customers who'd had their data averaged would then opt to undertake this review that you're describing.
Yes, that's how I'm interpreting, yes.
Okay. So that's a third of the 303,399 customers.
Yes.
The balance of those, it was assumed, would not so opt.
That's what the assumptions are saying, yes.
And that debts would be raised against them based on averaging.
Yes.
Now, my rough maths is that's about 200,000 customers, correct?
Yes.
Bearing in mind that only prior to this process, 20,000 interventions were conducted per year, that is a substantially increased number of recipients whose entitlements would be calculated according to income averaging, isn't it?
Yes, it is.
Can you put that back?
Did you ever come across any figures that told you how many people had had income averaged before?
No, I don't believe that that was something where we had management information on, Commissioner. So I don't think that was something that could be extracted from the system.
Thank you.
Well, you knew, didn't you, that under the previous process, there were processes that the department followed before calculating debts based on income averaging, correct?
Pardon, can you repeat that?
You knew that under the previous process, the department had processes to be followed before calculating debts based on income averaging.
Yes.
Those would include attempting to contact employers, for example,
Yes.
and obtaining actual income data from the employers.
Yes.
And then there's also the work that compliance officers would do to review the file to ascertain the accuracy of the averaging,
Yes.
whether there might be some explanation for the discrepancy between the ATO data and the declarations to Centrelink.
Yes, correct, yep.
And it intuitively makes sense, doesn't it, that to the extent that any debts were calculated based on averaging, it wouldn't be the entirety of the 20,000 interventions per year.
Sorry, I didn't understand that question.
It intuitively makes sense, doesn't it, that the extent to any debts were calculated based on averaging under the previous process, it wouldn't be the entirety of the 20,000 interventions per year.
No.
And indeed, it may well be only a fraction of any debts that were calculated under the previous process.
It would be I don't have the information about what percentage, but I agree it would be a small percentage.
Yes. So in light of all of that, based on the assumptions disclosed in this document, would you agree with me that what was proposed was a fundamental change to how income was assessed or overpayments calculated?
No.
Why not?
At the time, obviously income was still being assessed on a fortnightly basis. Debts were calculated on the difference between the fortnightly amount and the amount declared to the agency. The way by which the agency determined that fortnightly amount using averaging was still the same, but on a lot higher scale.
Sorry, didn't catch.
So I'm saying that, the way by which we determine the fortnightly amount is to use the period of employment and to calculate it to a fortnightly amount. And so that was happening at that point.
But under the previous process, as you've agreed, averaging only featured in a small percentage of the debts calculated. Correct?
Yes, I agree with that.
And what was proposed was a dramatic increase in the use of averaging.
From the assumptions, yeah, and the volume, yes.
And more than that, it was now to be the default position if you hadn't other information or without looking for other information, the default position was averaging.
Yeah, agree, Commissioner.
And that was a fundamental change. To how income was assessed or overpayments calculated, wasn't it?
No, I still maintain, Council, that it was still based on the same premise we were using at the time.
Which was?
It was based on the fortnightly amount debts are calculated on the back of the difference between the fortnightly amount and what's been declared at the agency. What informed the fortnightly amount was the averaging. That was still happening. That was happening, under the prior process. I agree, at a lot smaller rate.
As a last resort.
As a last resort, after other steps have been taken, yes.
And therefore had an impact on only a fraction of the debts that were raised.
Yeah, I agree. It had only had an impact on a fraction, yes.
Thank you. And notwithstanding that, you did not recognise that what was proposed was a fundamental change to how income was assessed or overpayments were calculated.
No, at the time, I don't think I did, no.
Do you recognise now that it did?
Absolutely.
Okay. Can you explain how you didn't recognise it at the time?
Because at the time we were, well, and again, I'm trying to go back, but at the time we were of the belief that we were still, that averaging had always been used. We were still calculating, we were still looking to use averaging as it had been used in a smaller amount to come to a fortnightly, to break that into a fortnightly amount and then calculate the debt on the back of it.
All right. That document can be taken down. I'm going to ask that you be shown a document behind tab 17 of the folders that I've been asking you about, Mr. Ryman. It's Exhibit 2066, doc ID CTH.2004.002.0332_R. Now, that should be a chain of emails, Mr. Ryman, starting on the 20th of January 2015. You see that?
Yes, I do.
You look at the bottom of that chain, it's an email from Kath Halbert. Do you recall who Kath Halbert was?
I recall the name, I don't recall exactly who she was.
Okay, would you recall she was a employee of the Department of Social Services at the time?
Yes.
Do you see that the subject is DSS comments on DHS welfare integrity options doc?
Yes.
And you see the email says, Melissa, as discussed, here are our comments on the compliance part of the brief. We feel particularly strongly about the Clean Up PAYG measure. You'll see the comments. You see that?
Yes, I do.
Now, it refers to a brief. Now, do you recall that about this time, DHS was developing a brief to Minister Morrison relating to the proposal that became Robodebt?
21 Jan, 20 Jan. I think it was around the same time.
You recall that?
I recall there was a brief being prepared for Mr Morrison, but I wasn't involved in its preparation, so I'm sort of not able to give you an exact on the dates.
Okay. But you're with me that it was around that time?
Yes.
Okay. And then in response, not in response, I should say, forwarding Ms Halbert's email addressed to, amongst others, addressed to Mr Withnell and Ms Golightly, referring to DSS's comments and identifying the key area of concern is the Clean Up PAYG measure.
Yes.
See that? And then you see the email from Mr Withnell to, amongst others, Mr Britton on the 21st of January 2015.
Yes, I do.
And you see it says, for your consideration, in bold, do not forward.
Yes.
Okay. Can the witness now be shown, and this is behind your tab 18, I think, Mr Ryman, Exhibit 2067, doc ID CTH.2004.0002.0333. Have you got that document, Mr Withnell? Sorry, Mr Ryman?
Yes, I do.
Thank you. Now, this is... I'm going to ask you about your knowledge of this document shortly, Mr Ryman, but I just want to establish with you what it is. Mm-hmm. Do you see the heading, proposed changes to strengthen the integrity of the welfare system?
I do.
And then you see various paragraphs followed by a box headed General Comments.
Yes, I do.
And then if we go over to the next page, 2 of 8, and then you see the heading Potential Priority New Policy Proposals.
Yes.
Now, do you see the heading under that, PAYG Cleanup?
Yes.
And then you can see a series of subparagraphs.
Yes.
I just want you to read those subparagraphs to yourself, not aloud. I'm going to ask you some questions about it.
Yes.
Now, do you agree with me that is a description of what became the Robodebt scheme?
A general description, yes.
Thank you. Now, I'm going to ask you to read the bullet points in the square that is at the bottom of that page and then goes over the next page again to yourself, not aloud.
Yes.
Now, Mr. Ryman, do you recall seeing this document in January 2015?
No,
Never saw it.
never saw it.
Okay.
The first I saw of it was when I was provided the documents in preparation for this hearing.
Okay. Well, we'll discuss that shortly. But for the purpose of my first few questions about this document, I just want you to assume that what this document is an extract from the draft brief to Minister Morrison in 2015 with DSS's comments on that brief in the boxes that appear in the document, including in that box that starts at the bottom of page 2 and over to page 3. That is the comments that Ms Halbert referred to in the email that we looked at a short while ago, where she mentioned how strongly they felt about the PAYG clean-up proposal.
Yes.
Now, having read that, do you agree with me that it is clear that DSS strongly advised against the proposal?
Yes.
And I just want to ask you about the second bullet point in that box. DSS Public Law Branch confirms that the suggested calculation method does not accord with Social Security legislation, which specifies that employment income is assessed fortnightly. Do you see that?
Yes, I do.
Now, are you aware that the DSS Public Law Branch was comprised of lawyers?
Yes.
And are you aware that what that bullet point is conveying is the effective legal advice that what was proposed was unlawful?
Here they're saying it doesn't accord with legislation.
Sorry,
It's clear they're saying it doesn't accord with legislation.
which means it's unlawful. Okay. And you see in the first bullet point the words, the proposal fundamentally changes the assessment of income.
Yes.
Thank you. Tab 22. Mr. Ryman, I'm going to ask you about a document behind tab 22 of your first large bundle. Should be Exhibit 5512, Doc ID CTH 3023.0013.3217_R.
Yes.
First thing I'd like you to note, Mr. Ryman, is the date of the email chain, dates of the emails in this chain that appear in this document. They start with an email from yourself to Tennille Collins and Michelle, is it Pohl?
Michelle Pohl, yes.
On the 21st of January 2015.
That's right.
And you recall the email I showed you the email from Mr. Withnell headed "Do Not Forward" was the 21st of January 2015
Yes, I do.
at 9:37 a.m. What tab number was that? That was tab 17, Mr. Ryman.
Thank you. Yes, I do.
And then your email at the bottom of this chain is at 12:50 p.m. the same day,
Yes.
a matter of hours after Mr. Withnell's "Do Not Forward" email.
Yes.
You see the top of the page is headed FW:DSS response dot points.
Yes.
Okay. And your email at 12:50 p.m. addressed to MP, being Michelle presumably, and TC being to Neil, review my comments, hand on heart time, any exposure,
Yes.
and then says, as requested, PAYG cleanup.
Yes.
And would you agree with me that in a general sense, what seems to be done in this document is an attempt to respond to the criticisms of the proposal in the document that we just looked at before?
I can't agree with that.
Why is that?
I was not responding to that document.
What document were you responding to?
My recollection, I was asked to provide some dot points for Scott Britton in relation to why we think we can do this.
Well, the top of the page has DSS response dot points.
Yes.
And we just looked at a document that sets out dot points outlining why DSS opposed the proposal.
Yes.
And it's a document that was forwarded to Mr. Britton from Mr. Withnell a matter of hours before this email.
Yes.
Can you think of any other document that you were responding to that day at that time?
I wasn't responding to that document.
What document were you responding
I
to?
wasn't responding to a document.
I see. So what led to this email?
I was requested by Scott to provide some dot points for DSS.
Right, and for what purpose did he disclose?
I don't recall exactly, but I think it was along the lines as to, can you prepare some dot points of why we think we can do this?
Right. And the heading, the subject line for your email is DSS response dot points.
Yes?
So it's evident, isn't it, that you're seeking to respond to what DSS have said?
No, don't agree. The heading DSS response dot points, I would agree that the dot points was prepared for Scott to respond to DSS about something, but I'm not responding to a document.
Right. So you were not aware at the time of this email of what you were providing the dot points for?
No,
Mr. Britton didn't tell you?
no,
He didn't show you that?
no.
Right. So you were just stabbing in the dark as to what to address?
It was, please provide, again, the dot points are fairly general and saying they go to why we think we can do this, why we think this is a doable thing.
Okay. So, can you explain what you meant by the words hand on heart time, any exposure?
I'm not sure if it's language I use often. I'm asking, have I got, I would suggest I'm saying, have I got the points I've raised right?
What would be the possible exposure that you would have in mind in this email?
Exposure. That I've incorrectly, I've articulated something incorrectly.
Okay. What would your exposure be if you articulated anything incorrectly?
What would the exposure be? Well, I'm not providing correct information to Scott.
I see. And what would that exposure be?
I don't know.
You don't know?
No. It's a fairly flippant statement I've used there. Hard on any exposure. I can't really elaborate on it.
See, what I suggested indicates is that you recognise that you're dealing with, that the response had some serious implications.
Right.
Do you accept that?
No.
That you recognised that I'll withdraw that. I'll put it this way, Mr. Ryman. If you had seen the comments from DSS,
Yes.
you would have known that you were dealing with very serious concerns held by DSS about the proposal,
Yes.
including that what was proposed was unlawful,
Yes.
and that continuing to advocate for the proposal without proper basis could create significant exposure, correct?
Yes, it could. I would believe so.
Exposure to yourself?
To myself? Well, I think it certainly raises issues that needs to be addressed, yes.
Exposure to the department?
Yes.
And can you think of any other explanation for why you use those words, any exposure?
No, I can't. Again, it would be, I'm asking a question, may have been, Scott may have asked, I need really, your absolute points as to what we think, why we think we can do this. So I'm trying to get as accurate as possible.
Okay. Oh yeah, where did you get the words PAYG clean up from?
I don't know.
See, those words were used in the document that we've been discussing, weren't they? That was how the proposal was described.
Yes, it's described that way in that document.
That suggests, rather, Mr. Ryman, that you did see the document.
No, I don't agree. The first time I saw the document was a couple of days ago.
Okay. Well, having reviewed the document,
Yes.
do you accept that the dot points in this email from yourself on the 21st of January 2015 at 12:50 p.m. did not actually address the concerns that DSS had raised?
Do I accept, sorry, Council?
Do you accept that these dot points in this email from you, the 21st of January 2015 at 12:50 p.m, did not actually address the concerns which DSS had raised?
I haven't done a comparison. Council.
Well, it certainly didn't address the concern that the proposal was for unlawful conduct, did it?
No.
I'm going to ask you now, Mr. Ryman, about a document behind tab 117, which
Sorry, document.
tab 117, which should be, I think, perhaps your second volume.
Yep.
Exhibit 5617, doc ID CTH.4700.0001.2404_R. Have you seen that document before, Mr. Ryman?
Yes, I've seen this document before.
Have you?
I've seen it in the package of information, and it was, I believe, sent to me sometime late February 2015.
24 February 2015?
It's possibly right, yes.
Okay. Sorry, I beg your pardon, 26 February 2015, I misspoke. And you recognise this is the brief to Mr. Morrison in February 2015, which outlined, among other things, the proposal which became the Robodebt measure.
Yes.
All right. We go, please, to page 10 of the document. Pull out the last bullet point on the page. Before I ask you questions about it, Mr. Ryman, just read to yourself what's on that page to refresh your memory, please.
Yes.
Now, do you agree with me that outlines what became the Robodebt scheme?
Yes.
including the use of ATO data to calculate and raise debts
Yes.
with the method of income averaging?
If it's okay, I'll have a quick read again.
Sure.
I don't see where it talks about income averaging specifically.
Not specifically, but it's obvious that's what it's talking about, isn't it?
I think it can be implied, yes.
Yes. And by the way, it was always, at every stage of the development of this proposal, the case that income averaging would be used to calculate and raise debts if the customer did not respond to the letters sent to them at the start of the process.
Yeah, as far as I can call, yes.
Okay. It never changed,
No.
not after this brief, and did not change. Sorry, I'll let you answer that question. Did not change after this brief, correct?
I wasn't privy to this brief. But yes, it didn't change after this brief.
Right. And that was still the effect of the proposal up to the decision of Cabinet to adopt it in March 2015?
Yes.
Thank you. When you say you weren't privy to the brief, you saw it, you received it on the 26th of February though?
Yeah, I see in my documents I did receive it 26th of February. I don't recall reading it, but I did receive it, yes.
You don't recall reading it?
No.
Well, can you see what's called out on the screen there? That's the last bullet point on the page.
Yes?
Do you agree with me that aligns with the position that had been communicated by DSS in January 2015, that the proposal to use income averaging to calculate and raise debts would not be consistent with legislation?
Yeah, it provides a very brief summary of that, yes.
Yes. Now, you say you didn't read this document when you received it.
I don't believe I did.
Okay. Well, can you just have a look at the document behind tab 74, Mr. Ryman, which should be exhibit 5574, CTH.2002.0005.4677 _R.
74, you said, yes?
Yeah. Now, do you agree with me? This is the email which is in the middle of the page from Mr. Britton at 26 February 2015 to yourself.
Yes?
Attached that brief that we just discussed.
Yes?
You were the only recipient of that email.
Yes?
It wasn't copied to you.
No, I was a recipient.
Okay, so can you explain why you didn't read the attachment?
I recall on that date I received a whole lot of documents from Scott, including a new MPP template and other budget proposal documentations that he asked to have them completed as quickly as possible.
Right.
And so there was a number of documents and I don't recall reading them all, no.
Well, do you agree that the minute that we've just been looking at is the instrument by which the Minister authorised the development of the proposal?
Yes.
Wasn't that a fundamental document to look at if you were to be involved in the development of the proposal?
It probably would have been, yes.
So therefore, in the ordinary course you would read it, wouldn't you?
Yeah, normally, of course I would. I just don't recall reading it.
Right, so you don't recall reading it,
No.
but you can't think of any reason why you wouldn't.
No, except for what I described, but I was sent a whole lot of documents and with the instruction to just put the first draft of the new policy proposal, or alter a new policy proposal template and to complete that.
Can I just clarify that, is this the effect of your evidence? You don't have a recollection of reading it,
Yep.
but in all likelihood you did.
I don't have a recollection of, my evidence is I don't have a recollection of reading it. I'm not saying that I didn't read it, but I don't have a recollection of reading it.
Do you agree with my proposition that in all likelihood you did?
No.
Why?
How are you going to work up a new policy proposal if you don't know what the proposal the minister has adopted is?
Commissioner, there was a new template provided and we sort of had previous versions of the new policy proposal. And so I was asked to quickly draft up, translate that previous into the new template, and that was my focus.
Without reference to what the minister had actually approved?
I just don't recall reading it.
Okay.
Well, I suggest you did, Mr. Ryman. Do you accept that?
You suggest I did?
Yes, I'm asking whether you accept that.
Well, that's a bit ambiguous. Are you asking him whether he accepts that you're suggesting that, or?
Sorry. I said, do you accept that you did read it, Mr. Ryman?
I can't confirm that. All I'm saying is I don't recall reading it.
Okay. I just ask you to look at the document behind tab 127, Mr. Ryman. It's exhibit 5627, doc ID CTH.3756.0001.0050.
Yes.
Do you have that, Mr. Ryman? Do you agree with me that is an email proposing a meeting on the 27th of February, including with yourself, Mr. Britton, Mr. Withnell and Mr. Kimber and Mr. McBride?
Yes.
Do you recall attending that meeting?
I don't recall specifically, no. I think I'll put that in my statement.
You don't specifically recall attending the meeting?
No. But I recall being invited to the meeting, but I don't recall attending.
Okay. So you have no recollection of what was said at the meeting?
No.
Can a witness, and this is behind your tab 15, I think. Oh, no, it's not. I don't think you have a copy of this, Mr. Ryman, but if we can, the witness please be shown exhibit 5651, doc ID CTH.3095.0002.4674. See, that's an email from Ms. Golightly to Ms. Wilson, dated the 26th of February 2015.
Yes.
Now, of course, you recall who Ms. Wilson was.
Yes.
Deputy Secretary was Ms. Golightly's counterpart. Deputy Secretary, DSS, counterpart to Ms. Golightly, correct?
Yes.
You see the email says we've received the signed compliance brief back from Minister Morrison. Mark Withnell will bring over a hard copy when he meets with Paul and Murray tomorrow, but in summary, Minister Morrison has supported all three overarching recommendations. Basically, he agrees to the development of a package of measures, that we continue to work with you on the policy and legislation aspects of the package, and that he notes the current arrangements in place to protect the integrity of welfare payments. You see that?
Yes, I do.
You recall in the brief to Morrison in that last bullet point reference to an intention for the two departments to work together?
Yes.
Okay. Does this refresh your memory at all about the subject matter of the meeting on the 27th of February, noting that you're not specifically mentioned in this email?
No.
Okay. Now, can you go to your tab 31, Mr. Ryman, exhibit 5521, doc ID CTH.3023.0001.5316_R?
Yes.
Okay. You see there's an email from yourself to Mr. Britton dated the 26th of February 2015 at 4:38 in the afternoon,
Yes.
the date before the meeting on the 27th of February.
Yes.
It says see attached and it refers to an attachment, strengthening the integrity of welfare payments, NPP.
Yes.
Okay. And the next document in your bundle, I think, is the attachment, which is exhibit 5522, CTH.3023.0001.5317_R. See that, Mr. Ryman? Do you recognise that as a draft new policy proposal?
Yes, I do.
The attachment to the email we just discussed?
Yes.
All right. We go to page 2 of the document. Page 2, please. While that's being brought up. Yes. Can you see, Mr. Ryman, below, the paragraph just below the redaction on the document?
Just below the redaction?
Yeah. Commences in addition to current activity
Yes.
and describes that the approach will involve presenting to the customer via their online account information obtained from the ATO, the amount they declared to us, and an assessment of their correct welfare entitlement based on this information. This assessment will be based on the fortnightly attribution of the income advised by the ATO, equally distributed over the duration of employment for the period the customer was on payment. Do you see that?
Yes, I do.
Do you agree with me that it clearly indicates that the proposal included a proposed assessment of social security entitlement based on averaging?
Yes.
Thank you. Now, if you could go to your tab 75, Mr. Ryman, exhibit 5575, doc ID DSS.523.0002.2174_R. This is an email from Mr. Kimber on the 15th of January 2017, and I appreciate you're not someone who's involved in this email itself, but I'm just going to ask you about the section headed 27th February meeting. And perhaps if you just read the first 2 paragraphs above that heading before I ask you some questions about it.
So you want to read the
section starting apologies and then the section under the heading background, just to yourself, not allowed.
Yes.
All right. So with that context in mind, do you agree with me that the 27 February meeting referred to under that heading 27 February meeting is a reference to the meeting on the 27th of February 2015?
Yes.
It describes attendees as including Mr. Withnell, Mr. Britton, Mr. Kimber and Mr. McBride.
Yes.
You're not referred to as an attendee.
Yes.
Okay, but bearing in mind that there was that meeting invite we just discussed earlier that you were at least proposed to in that meeting. And the description states at the 27 February meeting, DHS outlined a revised proposals that would use newly available data sources and analytical tools. The bullet point describes DHS targeting identified discrepancies based on PAYG files. Where a significant discrepancy is detected, this information will be presented to the recipient. This will not be a debt notice, but rather the recipient would be afforded the opportunity to explain, correct, update or challenge the information. Then states any subsequent debt raised would take into account the information provided by the recipient. And then it says, DHS also advised that there would be no change to how income is assessed or overpayments calculated as part of this proposal. Now, just to be clear, do you have any recollection of attending a meeting where something to this effect was said by representatives of DHS to representatives of DSS on the 27th of February 2015?
No, don't have the recollection.
Okay. Do you have any recollection at all of any discussions between yourself, Mr Withnell and Mr Britton about DSS opposing the proposal in January and February 2015?
Nothing I can recollect, no.
So you heard nothing about DSS having concerns about the proposal?
Not that I recollect.
And you have no recollection of any discussions with Mr Withnell or Mr Britton before this meeting of the 27th?
I don't recollect having a previous or a pre-meeting prior to going to this, or the meeting being set.
Or after?
I don't have a direct recollection, but I do believe there was feedback provided after.
After the 27th of February?
Or after this meeting.
So you're aware the meeting occurred?
Yes.
All right. How did you become aware of the meeting occurring?
How to become aware of the meeting that occurred? Well, my recollection of events is on the afternoon of the 27th. I made a number of updates to the MPP, the new policy proposal.
Updates after what happened?
After what happened.
Yeah, what specifically happened that led you to making those updates to the NPP?
I don't recall specifically. They're not updates I would have made autonomously, so I would have been directed to make updates.
By whom?
Would have been either by Mr Whitnell or Mr Britton.
Okay. And was that in the context of you being informed of the feedback following this meeting?
Either informed of it or if I was at the meeting.
Okay. Just want to ask you about those words. DHS also advised that there would be no change to how income is assessed or overpayments calculated as part of this proposal. Do you accept that if that was said at that meeting by a DHS representative, that was contrary to what you knew of the proposal?
Contrary? I'm not sure I understand your question, Councillor.
Okay. Well, let's take it in steps. Assuming that a DHS representative stated those words, there would be no change to how income is assessed or overpayments calculated as part of this proposal.
Yes.
Do you accept a statement to that effect was not true?
No.
So you believe, sorry, at your understanding at the time of that meeting of the proposal is consistent with that statement?
I think we discussed this earlier and I, at the time, believed this would be a correct statement.
Right. Okay. Well, based on what you now know, do you accept that it's not a true statement?
Based on what I now know, yes.
But did you give DSS to understand that you changed anything you were doing?
Pardon, Commissioner?
Well, you had this proposal.
Yeah.
Did you give anybody in DSS any reason to think that you had changed what you were doing?
I don't believe so.
So nothing was said to anybody in DSS to suggest that concerns about averaging or anything else were being taken into account to adjust anything?
As Commissioner, as I described earlier, I think from my perspective, income average was always going to be part of a feature of the measure.
And you never told DSS any different?
No, not from my point of view, no.
And they always understood that as far as you could tell?
I believe so, but I'd note that I do reflect on some emails I've seen, and Scott's asked me to go and have some discussions with DSS because he feels that they didn't completely understand.
So when did you do that?
Oh, that would be, I would say probably more like, probably March 2015.
And who did you explain it to?
I think Catherine Dalton was my contact point at that time.
Okay, so you explained to her how this was going to work and how there'd be averaging if someone didn't respond or agreed with the figures?
Yeah, and we had process maps, Commissioner, high-level process maps that I remember talking to them about.
Anybody else that you told?
That I told or spoke to.
Explain the process to.
Oh, I think there may have been other people within Catherine's team there, but I don't recall specifically.
What about Murray Kimber? Did he understand?
Oh, I would think so, but that's probably a better question for Scott Britton.
Okay. Where's the revised NPP, Mr. Scott?
I'll get to it now, Commissioner.
Okay.
Your tab 35, Mr. Ryman. Exhibit 5526, doc ID CTH.3023.0001.5380_R. You have that?
Yes.
It says, Scott, here is the latest version. I would like to ensure it is going in the right direction so we don't get to the end of the day and have to start again.
Yes.
Can you explain what those words, we don't get to the end of the day and have to start again, might mean?
I believe I'm talking to that we're making significant updates to the MPP. I've been asked to make significant updates to the MPP and, I've provided him what those updates look like and to make sure I'm on the right track, that he's happy with the way the MPP is shaping.
Okay. Then your tab 36, Mr. Ryman, exhibit 5527, doc ID CTH.3023.0001.5381.
Yes.
Now, have you had a chance to look at this document in your preparation for today?
Yes.
Except that's the attachment to the email we just discussed.
Yes.
That is the email sent the afternoon of the 27th of February.
Yes.
Is this the revision to the NPP that you made on direction from either Scott Britton or Mark Withnell following that meeting?
Yes.
Okay. We go to page 3 of the document,
Yes.
second paragraph.
Yes.
We can see in track changes the amendments.
Yes.
Do you see, first of all, the new words added? The new approach will not change how income is assessed or overpayments calculated.
Yes.
And that's consistent with Mr. Kimber's description of what DHS informed DSS at the February meeting.
Yeah, from that previous email, yes.
And the words acknowledging that averaging would be used in the process are deleted.
Yes.
And are you, based on your evidence you just gave a short while ago, is it your position that these amendments were made at the direction of either Mr. Withnell or Mr. Britton?
Yes.
Do you know why?
These wouldn't be updates I'd make autonomously. These would be, I'd already provided a draft and that had gone up the line. At this level, I would have been asked to make these updates.
Okay, so did they communicate to you why that they directed you to make those updates?
I can't recall specifically, and I don't have an email to say here's the updates that are required. So I believe I've been verbally advised.
Okay.
You notice they take out reference to averaging,
I do.
basically.
Yes.
Got any sense of why that was?
No, because it was in every other version of the MPP that I'd been involved in drafting.
Do you accept that at no stage after this, prior to the Cabinet decision, were any versions, any subsequent versions of the MPP acknowledged? Sorry, I'll withdraw that. I'll start that again. Do you accept that in any subsequent versions of the MPP that you saw, there was never any explicit acknowledgement that averaging was proposed?
I don't recall seeing it going back in, no.
And you understand that it's a situation where the reference to averaging is taken out after DSS has said it doesn't conform with the legislation, it's not lawful. So it looks very much as if it's been removed to deceive people into thinking it's not happening. Do you accept that much?
Yeah, I see your point, Commissioner.
Can you shed any light on that?
No, I can't. I certainly haven't done that to mislead anyone. I've been operating under instruction, is my belief, because every other version I'd had been part of back from 2014 through had included it.
All right. Do we have the chain of documents where the instructions are given to remove it, Mr. Scott?
No.
Have you?
No, I think I just mentioned before, Commissioner, that I didn't have, in review of my documents, I didn't see an email or anything to say, here are the changes to be made. So my belief is that I was provided verbal instructions from Mr Whitnell or Mr Britton.
Without explanation?
Possibly could have been explanation, but yeah, I don't recall specifically.
Okay.
Now, I'm going to ask you about a document behind tab 46 of your folder, Mr Ryman. It's Exhibit 5546, Doc ID DSS.50006.0002.3934_R.
46, yes.
Now, you see that's a chain of emails from the 20th of March 2015. That's the first email on the chain on the second page.
Yes.
And you see there's a reference, that email is from Mr Barford on the 20th of March 2015.
Yes.
Referring to an update checklist following this morning's discussion with Jason at DHS.
Yes.
So that's a discussion that seems to have happened on that date. See that?
Yes.
Do you recall?
I don't recall specifically, but I do recall that I had meetings with DSS. Yes.
Okay. And if we go then, please, to the document behind tab 45.
45?
Yes. DSS.5006.0002.3936.
Yes.
Have you seen this document before, Mr Ryman?
Yes, I have.
Can you tell us what it is?
It was a document that was provided by DSS and incorporates, from my understanding, their summary view of the measure, questions that they had, and their view of what their DHS detailed advice. So their very brief assessment of what DHS advised them.
Okay, so if we go to the last page of the document,
Yep.
section headed PAYG cleanup.
Yes.
And is this something that was provided to you, this document?
I believe it was sent to me at some point.
In March 2015?
I believe it's in my statement, Council. Can I look at my statement?
Yes, please. Is that your supplementary statement, Mr. Ryman? What paragraph? Oh, okay. It might assist, Mr. Ryman, if you have a look at your tab 105, Exhibit 5605, Doc ID CTH.3023.0006.8875_R. Can you see that document on the screen, Mr. Ryman?
Yes, I can, yes.
So, and you see the attachments listed at the top?
Yes,
The date of the email, 24 March 2015.
yes.
Do you agree that's the email by which the previous document we were looking at was sent to you?
I'm not 100% sure, sorry, council.
Do you need to refer to your statement?
Yep. So I've just got a different document reference in my statement. I believe it is, council.
Okay, thank you. Now, just so we understand, if we go back to the previous document, the previous document we had on the screen, that is the DSS.5006.0002.3937, and go to the last page of that document.
Yes.
And the document refers to DHS detailed advice. You've got that?
Yes, I do.
Now, am I right in understanding that that reference to DHS detailed advice is advice that you provided at the meeting on the 20th of March 2015?
No, it doesn't. It doesn't link with me. Same basic process current, not using ATO TFN data. So it looks like that first dot point talks to about the data matching element. How we actually undertake the data matching. Potential for payment period, salary and income period match to be resolved. I'm not sure what that reference is.
So you don't have a recollection of providing advice to that effect on the 20th of March 2015?
Oh, again, the first point saying basic process is current in terms of not using the ATO TFN, yes, that's a correct statement. We use the welfare file for the matching.
So what does that mean? When you say not using ATO TFN data, uses welfare file, what does that mean in layman's terms?
Oh, sorry, council. Under the Data Matching Program Assistance Act and the matching that's taking place there, that matching provides for the use of tax file numbers to match. Under the Office of the Information Commissioner's data matching guidelines, you can't use tax file number to match records, compare records.
Right.
And for the PAYG file, we don't match against the tax file number. We use a welfare file that's provided to the Australian Taxation Office to match against the PAYG data.
I see. So is that referring to the data that's being used in the matching process?
That's right, yes.
Right. And what are can you assist us as to what the words potential for payment period, salary or income period match issues to be resolved?
No, that doesn't make much sense to me.
Okay. Now, can you go to tab Okay, it's not one of your tabs, Mr. Ryman. It's an additional document. It's CTH.3023.0002.0501_R, exhibit 5653. Just look at the screen. Now, the bottom of that first page, there's an email from someone called Jenny Spokes. See that?
Yes.
Day of the 2nd of July 2015. It says, "Hi Jason, the GM has asked for amendments to the PAYG brief."
Yes.
See that?
Yes.
It refers to the pilot. Now, the GM would be Mr. Withnell, correct?
Yes, at that date, yes.
And then there's an email from yourself in the next email chain, and then an email to Mr. Britton on the 2nd of July 2015. Do you see that?
Yes, I do.
Now, the document which is attached to that email chain is exhibit 5654, CTH.3023.0002.0503. Do you see that is a draft minute to the Secretary
I do.
through Ms. Golightly? And can you see just from the description of the recommendation in the draft that it's referring to the pilot? See that?
Yes.
Okay, if we go to the next page, you see in the middle of that page the paragraph commencing, "An unexpected outcome is the percentage of customers." You see that?
Yes, I do.
And it states that what is the unexpected outcome, that is approximately 60% are not contacting, and that's from the results of the pilot.
Yes.
That is 60%.
Mary, the first initial pilot, 1,000 cases, yeah.
Yes.
Yep.
But 60% of customers sent letters, did not respond to them,
Yep.
and that was an unexpected outcome. And that's why that was unexpected can be seen from the document we discussed earlier about there being an assumption that it would be 35% of customers that would not respond.
Yes, agree.
Okay. It states that these customers have debts raised based on the match data and are sent a debt notice. See that?
Yes.
And then the next paragraph says, by providing details of their employment in the original letter to customers, it is possible that the customer is able to make an informed decision to not respond. Do you see that?
Yes.
And then the two bullet points below that talk about firstly, when customers contact over 50% agree with the data and request any debt be calculated on this information. And
Yes.
this indicates a high level of acceptance of the match data. And then the next bullet point, for customers who did not contact, only 1% of customers have contacted to provide information after receiving a debt notice. This indicates a level of acceptance of the debt. Do you see that?
Yes, I do.
Now, those conclusions that data indicated a level of acceptance of the debt, is that a conclusion that you formed?
I was aware of it. I'm not sure if that was a conclusion I formed.
Do you recall whether Mr. Britton or Mr. Withnell instructed you as to whether or not such a conclusion ought to be drawn?
No, I don't. I'm trying to work out, do we know, sorry, I'm unclear as to who drafted this secretary brief. Was that myself? Or was I making updates to it?
Well, you're in the email chain that we discussed, attaching it. I'm just asking you to speak from your recollection, Mr. Ryman.
And, sorry, can you repeat your question, Councillor?
So you see that the bullet points refer to the data indicating a level of acceptance of the debt. I'm just trying to ascertain whether that's a conclusion you drew, or was that just a view that you'd been directed to form by others?
Well, I don't know if I wrote that, but I think that was a view that was formed.
And was that view communicated to you by others?
Yes.
Who?
My first recollection of that was the monitoring of the pilot, and I think Tennille Collins was doing some assessments on the outcomes. Now, the first dot point, if you agree with the data, this indicates a high level of acceptance of the match data. I think that's reason, yep.
Is that do you recall who formed that view?
That's reflects a high level acceptance of the data?
Yes.
No, I don't. And that's what I'm trying to understand. Did I write this brief, or was that someone else? I'm not sure.
Well, perhaps if we go...
And for customers who did not contact, only 1% have contacted to provide information after receiving a debt notice, a level of acceptance of... Yeah, I don't know about that. I mean, and whether I'm looking at it with hindsight or at the time.
Can the witness please be shown Exhibit 5658, document CTH.3023.0002.8902_R? Now, do you see that's an email dated that's an email chain that ends with an email dated the 25th of November 2015?
Yes.
And if we go to the second page, second last email on the chain, do you see that's an email dated the 2nd of July 2015?
I see that, yes.
Do you agree with me? That's the email in relation to the same secretary's brief we've been discussing?
Yes, I agree, yes.
Okay, if we go to the first email on the chain. Call that out. Do you see that it says, it's dated the 25th email, from BI Operations Escalated Correspondence, dated the 25th of November 2015? See that?
Yes, I do.
And yourself and Mr. Britton are the recipients of that email?
Yes.
It says, "Hi Scott, BI Briefs has advised that the attached brief is not progressing to the Secretary."
Yes, I see that, yes.
Okay, now, do you agree with me that the brief that we're discussing is a brief that reported on the results of the pilot?
The initial 1,000 cases, yes.
And reported the unexpected outcome that 60% of recipients did not respond?
Yes.
Do you agree with me that you might expect a brief of that nature to progress to the Secretary?
Given the significance of the measure, yes.
Do you have any recollection of a decision made to not progress that brief to the Secretary?
No. I think that decision's made elsewhere, isn't it?
Sure.
Yeah. I don't have no recollection of why that hasn't progressed to the Secretary.
Okay. Now, can you have a look behind tab 106, please, Mr. Ryman? Exhibit 5606, doc ID CTH.3023.0006.8894_R.
Yes.
You had a chance to review this email in your preparation for today?
Yes, I have.
Okay. Now, do you agree with me that you are the recipient on the 2nd of March 2017 of an email from Maris Steepnex in this chain?
Yes.
And it forwards to you an email from Mr. de Berg dated the 1st of March 2017,
Yes, that's correct.
which indicated information outlined in that email was to be forwarded to the Ombudsman.
That's correct, yes.
And that information was to explain the circumstances of legal advice obtained by the Department of Social Services in 2014 and 2017.
Yes.
And we'll go to the attachment shortly, but an extract of those two advices was attached to that email.
Those two advices?
Yes.
Yes.
Okay. Now, do you recall receiving this email?
Yes, I do.
Okay. And do you recall that the 2014 advice?
Can I just correct that? Sorry, Council.
Sure.
I recall seeing it when I was preparing my statement.
Right.
I don't recall it at the time back in March
Right.
2017.
So do you have any recollection? Sorry, I'll withdraw that. I'll rephrase it. Do you accept from me? Sorry, I'll withdraw that as well. Do you accept that you would have reviewed this email?
Absolutely, yes.
Have you reviewed other emails to indicate that it attracted quite a deal of attention from you?
Say that again, please.
Have you reviewed, in the preparation for today, have you reviewed other emails indicating that when you received this email, you spent a bit of time considering this issue?
Still not sure of the question, sorry.
Have you reviewed other emails from this time in 2017 in which you demonstrate some attention being devoted by you to the subject matter of this email from Mr. de Berg and the advice from DSS in 2014?
When I was preparing my statement or
No.
at the time? Back in 2017?
No, when you were preparing your statement.
Yes.
Okay, so do you agree with me that once you received this email, it attracted a fair degree of attention from you?
When I was preparing my statement, yes.
No, but in 2017.
Commissioner, in fairness, the witness was asked to agree with it. It was in the period that he was preparing the statement and he agreed with that proposition.
All right, but just make your question clear. It's about 2017.
Yes, I apologise, Commissioner. I'm just wanting to ask you, Mr. Ryman, about your state of mind in 2017.
Yes.
And do you agree with me that upon receipt of this email, it would have attracted from you a degree of attention?
No, I don't. Again, I think I've expressed previously what my state of mind was around that period.
Okay.
But I will acknowledge when I was preparing my statement, it did attract my attention.
Okay. Well, you agree with me that the email from Mr de Berg indicates that in December 2014, DSS obtained legal advice to the effect that the proposal that became Robodebt was unlawful.
The email says, consider early version developed in Mr. Subject Ombudsman. And consider the need for legislative change. I think it says it's unlawful, just the need for legislative change.
All right, well, we might go to the attached email then, Mr. Ryman. Tab 107.
Yep.
Doc ID CTH.3023.0006.8897, Exhibit 5607.
Yes.
You have that there? If we go to the page headed 2014 advice,
Yes.
you can see under the heading 2014 advice, you have asked whether a debt amount derived from annual smoothing or smoothing over a defined period of time is legally defensible. See that?
Yes, I do.
And the answer is, in the short advice, in our view, a debt amount derived from annual smoothing or smoothing over a defined period of time may not be derived consistently with the legislative framework.
Yes, I see that.
Okay. Now, debts derived using annual smoothing or smoothing over a defined period of time was how debts were calculated under the Robodebt scheme, correct?
Where a customer didn't respond to us, yeah.
Yes.
Yes.
And the answer isn't qualified by reference to whether or not a customer responds.
Why is that?
I'm just referring to what's in the...
Oh, okay, yes, sorry. Yeah.
So it clearly states, doesn't it, a debt amount derived from annual smoothing or smoothing over a defined period of time may not be derived consistently with the legislative framework.
It says it may not be derived consistently with the legislative framework, yes.
Now, do you agree with me, therefore, that the use of averaging under the Robodebt scheme, according to this advice, was unlawful?
I don't think I could make that assessment myself based on this advice. It says may not be derived consistently with the legislative framework. I don't think that says it's unlawful.
Well, calculating debts inconsistently with the legislative framework is unlawful, isn't it, Mr. Ryman?
Calculating debts that are not consistent with legislation, yes.
That's right, and what it's saying is that the use of annual smoothing in the way that annual smoothing or smoothing over a defined period of time was not consistent with the legislative framework.
That's what it says, yes.
And clearly advising that, therefore, the use of averaging as it was being used in the Robodebt scheme was unlawful.
Sorry, Council, I don't go to that assessment, but I take your point.
Sorry, what do you mean you don't go to that?
I look at the advice may not be derived consistently with the legislative framework. So it doesn't say specifically this is unlawful, but...
It's the inevitable conclusion to be drawn from the statement, isn't it, Mr. Ryman?
I think you can draw that conclusion. I'm not 100% sure.
It's what it says, Mr. Ryman, isn't it?
No, it says it may not be derived consistently with the legislative framework. It doesn't say it's illegal. That's the point I'm making anyway. But
What other interpretation could you draw of the words, Mr. Ryman?
yeah, you are derived from annual smoothing of opportunity may not be derived consistently with the legislative framework. So it's saying it may not be consistent with the legislative framework. It's not saying it isn't consistent. It's not. It's may. The point I make. The only thing I'm stuck on is the may.
Right. So your interpretation of these words is that it's left open that may be consistent with the legislative framework.
Yes.
Thank you. Well, if you read the balance of the advice, is that possibility left open that you've just described?
So do you want to read the whole advice?
Yes, please.
Read it? Yes.
Do you think that possibility that you've just described is left open when the full advice is read?
No?
Except that it makes clear that the
I
use...
mean that I'm still of my previous view.
Well, the second last paragraph describes how under the legislation entitlement is to be calculated based on fortnightly income. You
Yes.
see that? You agree with me on that?
On a fortnightly basis, yes, I do.
And then the last paragraph states the proposal to smooth the debt amount over an annual amount or other defined period may not be consistent with the legislative framework described above. In order to correctly determine a relevant debt, it would be necessary to consider the amount of income received in each relevant fortnight in order to apply the income test in that fortnight. See that?
I do see that, yes.
And you can see, can't you, that what is being identified in the advice is that the proposal to smooth the debt amount over an annual or other defined period may be inconsistent with that requirement that income be calculated based on entitlement be calculated based on fortnightly income.
May not be consistent, yes.
All right, so you still say that this advice left open the possibility that it was lawful to use averaging to calculate debts under the Robodebt scheme?
I didn't say that left open that. I was just saying that it still uses the word may not be consistent, and I interpret may as not being definitive.
Right. Well, if we go back to Mr. de Berg's email,
Sorry, back to...
Mr. de Berg's email.
Yep.
If we go to the second paragraph in his email, second paragraph in what he proposed to be forwarded to DSS.
Look, Mr Scott, before you go on, how much longer do you want to be this evening? Because I really think the transcribers should have a break.
With this witness, probably about 20 minutes.
Okay, I still think they should have a break, so 5 minutes and then we'll come back.
All rise. The Commission stands adjourned for a short break. The Royal Commission is now in session. Please be seated.
Yes, Mr Scott.
106. Yes.
Oh, microphone.
Sorry. So for the record, this is Exhibit 5606 CTH.3023.0006.8894_R.
Yes.
Have that. In particular, Mr de Berg's email from the 1st of March 2017
Yes.
outlining what was proposed to be said to the Ombudsman.
Yes.
We go to the second paragraph, call out the words. This is referred to in the Department of Human Services ministerial brief provided by the Ombudsman's Office. See that in the second sentence of that paragraph?
Yes, I do.
And then it goes on. Specifically, DSS considered implications for the use of annual ATO income data for the purposes of calculating fortnightly payment entitlements. See that?
Yes, I do.
It says, at that time, DSS sought internal legal advice about the legality of using this income data to determine entitlement. See that?
Yes, I do.
It states, the advice received, round brackets attached, close round brackets, in December 2014 indicated that this approach would not be supported by the legislation.
Yes, I do.
Now, do you agree with me that's a reference to the advice that we've been discussing?
Yes.
And it's clear, isn't it, that what's being stated is that advice was that the approach that was proposed would not be supported by the legislation.
Yes, it says it indicated that this approach would not be supported by the legislation, yes.
So do you agree with me that the position advanced in this email was that the 2014 advice clearly advised that the proposal was unlawful?
No, I don't agree with that.
Why?
As I said, like I look at words like indicated and the may. I accept that it has questioned whether it would be consistent with the legislative framework. And Russell has said here that it indicated this approach would not be supported by the legislation. So I do accept that there is potential legislative issues here.
Substantial legislative issues, I would suggest, Mr Ryman, wouldn't you agree?
Substantial in what context?
Well, it was...
Substantial, oh, sorry, when you say substantial, I'm thinking it's substantial because of the significance of the measure?
Well, the significance of the measure and the significance of income averaging to the measure.
Sorry, can you repeat your question, Councillor?
Well, in light of the significance of income averaging to the measure and the measure's significance, didn't this raise a substantial legal issue as to the lawfulness of the proposal?
I certainly agree that it raised a legal issue. Yes, and it's the legality, raising a legal issue around the legality of the scheme, yes, that would be substantial.
Okay. And then in the next paragraph, there's this statement. Following this, DHS took DSS's concerns into account and made adjustments to the process. By early 2015, DSS gained a better understanding of how the revised process would satisfy legislative requirements. Now, that first sentence refers to DHS taking into account DSS concerns and making adjustments to the process. Are you aware of any adjustment to the proposal in light of DSS concerns that were made in 2015?
I always, as I've stated before, Councillor, income averaging was always a feature of the measure.
And there was no...
Unless there are other elements that they're referring to, but for income averaging, in my understanding, was always a feature of the measure.
Right, but in any event, you're not aware of any adjustments made to the proposal in light of concerns expressed by DSS. Correct?
Well, it states here in particular, DSS understood that the intended implementation model provided recipients with the opportunity to correct any information presented to them. So that's consistent with where we started and where we are now.
Right. So that's not a change.
No.
What about the next paragraph? A key difference between the measure as DSS originally understood it and the approach that was ultimately implemented is that averaged income is only used for the purpose of calculating entitlement and therefore debt when no other information is available and attempts have been made to seek information from the individual. See that?
Yes, I see that.
Now, the concept of no other information being available, I just want to ask you about that. Was averaging used under the Robodebt scheme when no other information was available?
Sorry, can I just take a second to reread this?
Sure.
So, sorry, can you repeat your question?
Under the Robodebt scheme, was averaging only used when no other information was available?
It was used when the customer didn't respond.
In circumstances where there was still other information available?
Yes.
So that's an untrue statement, do you agree?
It appears that way, but I'm not sure what the author of that's trying to convey.
Well, you knew that averaging would be used if the customer didn't respond, correct?
Pardon?
Averaging would be used if the customer did not respond.
That's correct, yes.
Circumstances where there are other sources of information that could be available, such as by undertaking inquiries with employers.
That's correct, that the agency would not be making additional inquiries.
Right. So that is a plainly false statement, isn't it? That is, that averaged income would only be used for the purpose of calculating entitlement and therefore debt when no other information was available.
I thought Mr Ryman had agreed with that, but
I find it an interesting paragraph when you look at the previous paragraph.
What do you mean by that?
Well, the previous paragraph that, the implementation model provided recipients with the opportunity to correct any information presented to them based on data matching, particularly apportioning income from the ATO. So, and then it goes, a key difference. So that paragraph to me reads that we'd be providing the opportunity to the customer to respond. It doesn't go into seeking additional information. So I'm not sure where this other paragraph, I don't quite understand the next paragraph because it's sort of written in a way where no information available and attempts have been made to seek information from the individual. I'm not sure what they're meaning by no other information. So I do agree, but I'm not quite sure what they mean by no other information.
Okay. Well, and you're also aware that the email relied upon and attached the 2017 legal advice?
Yes.
And do you agree, we can go to it, but do you agree with me that that advice simply answered the question as to whether or not averaging could be used as a last resort?
Can I have a quick look, sorry?
Sure.
So can you repeat your question? Sorry, Councillor.
So the question that's asked in the 2017 advice, at least as it appears in the attachment to Mr de Berg's email, is whether income averaging can be used as a last resort to determine a social security debt.
Yes.
Agree with me?
Yes.
And do you agree with me that under the Robodebt scheme, averaging was not used as a last resort?
I agree it wasn't used as a last resort, yes.
So that this advice had no relevance to the lawfulness of the Robodebt scheme.
I'm interested in the second paragraph from the bottom, where it talks about, in my view, reliable income information which makes it likely a person has been overpaid, even if the information has this effect if taken at an average rate, may justify the Secretary lawfully taking action. He goes on to say, it would be preferable the Secretary give the person an opportunity to provide information to allow an accurate rate to be determined prior to raising an overpayment. If the person does not respond and provide accurate information, it would be open to the Secretary to proceed to raise and recover a debt. So that doesn't infer last resort, or that we need to go to third parties to get additional information.
But that has to be understood in the context of the question that's been asked in the request for advice, doesn't it?
Does Mr Ryman's construction of this opinion matter? I'm just wondering. I mean, it may. I'm not saying it doesn't, but it's just not obvious to me at the moment.
I'm just trying to ascertain his level of understanding of the opinion, given it was forwarded to him.
Sure.
So your question is, how does that relate to the question that was asked? That's where I get where my attention goes. You've asked about a question of using income averaging as a last resort to determine a social security debt was lawful. This opinion seems to suggest that you do not need the last resort to make that determination.
Sure, but in the context where it's as a last resort, isn't it, Mr Ryman?
I think I agree the question talks about the last resort, but that's very clear, that statement, that paragraph, it doesn't talk about last resort. It's pretty prescriptive. It would be preferable for the Secretary to give the person an opportunity to provide information. If the person does not respond, it would be open to the Secretary to proceed and raise the debt. So it doesn't talk to last resort in that paragraph. It's in my mind, and this is how I'm interpreting counsel. That's.
Is what you're saying reflective of what was in your mind at the time of this email from Mr de Berg?
As I previously mentioned, I only recalled this email when I was preparing my statement.
So your answer that you just gave me is your interpretation of the document now, correct?
Yeah, that's right.
Okay. That document can be taken down. Can the witness be shown, and this is behind your tab 54, Mr Ryman.
Attachment, sorry.
Tab 54. Doc ID CTH.3020.9786_R, exhibit 5554. Now, do you recall this document, Mr. Ryman?
Yes, I do.
This is an advice dated 17 April 2015.
Yes.
If we go to the third page, bottom of that page, do you agree with me? It refers to your email of instructions that precipitated this advice.
Yes,
Do you agree with me? Those instructions were sent on the 9th of April 2015.
I do.
Now, are you aware that the Cabinet decision that approved the new policy proposal that became the Robodebt scheme happened in March 2015?
I do.
So it's after that decision.
Yes.
Now, if we go to page 2, question 4. Now, do you agree with me that describes in general terms the nature of the process that became the Robodebt scheme?
Yes, I do.
And it refers to averaging?
Yes, it does.
Can you assist us to understand why you were asking for legal advice in relation to the proposal in April 2015 after Cabinet had already approved the proposal?
I believe question 4 that I asked was originally, or a version of question 4 was originally drafted at an earlier date prior to Cabinet approval.
Sure, but why ask the question after Cabinet approval?
I can't answer that, sorry, I'm not sure.
Commissioner, that's the evidence of the witness.
I just want to ask you about that meeting on the 27th of February 2015, because you thought you might have been there.
Yep.
And I might have distracted Mr. Scott from asking you more detail about it. So if we can just get that up on the screen, it's DSS 5023-002-2174, and it's your, I think, tab 75.
75, thanks.
Yeah, and what I'm going to ask you to look at is the email that Mr. Kimber subsequently prepared about what happened at that meeting.
Yes.
Because you'll see in the email that he gives a background of DSS telling DHS in January and February 2015 that using annual income to calculate and raise a debt, by which he means the PAYG annual income, was not likely to withstand scrutiny and legislative changes would be needed. And that's because fortnightly payment calculations are the basis for social security. So that's his background. I'm not saying he necessarily said that at the meeting, but he says, at the meeting, DHS outlined a revised proposal that would use newly available data sources and analytical tools, and that's how it was, that the process wouldn't change how income would be assessed or overpayments calculated. There were some newly available data sources and analytical tools. It seems that that was perceived as this revised proposal as the means of avoiding what had been objected to in the form of averaging. Were you there? Did you hear that?
I can't recall if I was there. When you talk about that, Commissioner, and I read that, it feels to me as though Mr. Kimbers may have got confused other elements of the Strengthening the Integrity of Welfare Payments measure, which was introducing new analytical tools for other purposes, not for the employment income matching, or what was known as Robodebt.
All right.
And newly available data sources, I suspect that's a reference to the strength and the integrity of the welfare payments, which had a number of elements. Also had the use of, I think the new data source was referred to, and there was also AUSTRAC, we were talking about as a new data source. So I'm wondering whether that's his recollection may have confused a couple of points, Commissioner.
Okay, so that's a hypothetical response, I think, is it?
Yeah, it is. Yeah.
You don't know whether you were there or you weren't there?
No, I can't recall. I do recall it being invited. I don't recall the meeting, so I'm not sure.
Okay, so your best explanation is that he's mixed up what DHS people said to him?
Possibly, yes.
All right. Anything out of that?
No, one question that I omitted before I concluded, Commissioner. Your tab 133, Mr Ryman, exhibit 5633, ID CTH.3023.0006.
Sorry, 13.
Tab 133, doc ID CTH.3023.0006.8872_R, exhibit 5633.
Yes.
I just want to call out the email from yourself to, is it Hong Zhang, dated
Yes.
7th of March 2015? Is that right?
Yes.
Thank you. You refer to, "Hi Hong, can you please send back to Catherine?" And what follows, do you agree, is some words that you were proposing to be emailed to Catherine Dalton?
Yes, agree.
All right. And those words include these words. We provided some comments back to Finance late yesterday through DSS on the costing assumption. They did raise the averaging, which we hope we have now adequately explained. Can you assist us as to what that's a reference to? That is, those words, they did raise the averaging, which we hope we have now adequately explained.
Comments back. So through that negotiation process with Finance, you get a lot of questions back and forth around assumptions, and no, they did raise averaging, and I'm not sure on the only thing I can say, Council, is I'm not sure in what context they raised averaging and whether it was about how we used averaging for the purposes of the savings calculation, or averaging in the context of the application within the measure itself.
But you don't have a recollection?
Of not what that response was.
Okay. Commissioner, that's it.
Ms Hogan-Doran?
Nothing arising, Commissioner.
All right, thank you. Do you... You're right. Do you want Mr Ryman excused?
Yes, please, Commissioner.
Yes, thanks, Mr Ryman, you're excused. And look, I heard that you'd had some threatening comments made to you, and I'm sorry to hear that. It's not only unlawful, it's stupid. So I regret to hear that you've been exposed to that as a result of giving evidence here.
Thank you, Commissioner.
All right, thank you.
Before we adjourn, Commissioner, there's
Yes.
some documents that were referred in the re-examination by my learned friend, Mr Ffrench. Can I just put on record the exhibit numbers for some of those documents and also exhibit some other documents that haven't been made exhibits? So firstly, doc ID CTH.3004.0011.6338 is exhibit 5373, I beg your pardon.
And what is it?
I beg your pardon.
What is it?
It's exhibit 5373. It's already
Okay, but does it have an identity as a document? What is it?
It's already an exhibit, but the identification.
But just tell me what you're talking about.
Certainly, it's an email, all clearance, Secretary's email to Michael Manthorpe.
Thank you.
Thank you, Commissioner. Then doc ID CTH.3004.0011.6339 is the attachment to that, which is the draft email to Mr Manthorpe, and that's exhibit 5374.
Thank you.
The following documents aren't yet exhibits. Doc ID CTH.3004.0011.6397. It's a draft email to send to the Ombudsman it's an email dated 5 March 2019 headed draft email to send to the Ombudsman-EIC process. We propose that be Exhibit 5374 capital B.
5374 capital B, all right.
Document CTH.300400011.6398 is the draft comment on legality part of the draft Ombudsman report. We propose that to be Exhibit 5374 capital C.
All right.
Document CTH.3004.0011.6400 is another draft of the email to the Ombudsman. We propose that to be Exhibit 5374 capital D.
Right. 5374D.
And document CTH.3004.0011.6341 is another annotated version of the comment on legality section of the draft Ombudsman report. We propose that be Exhibit 5374 capital A.
Sorry, I didn't catch that. Was what?
5374 capital A.
And Commissioner, can I just assist you further by indicating that that last exhibit is the additional attachment to Exhibit 5373, so that 5374 is the first attachment and 5374A, that was the last one dealt with, is the next attachment.
Right.
And then the other annotation, sorry, the other document which is similarly annotated but is the same as Exhibit 5374A is the one ending in 6398, which I believe would be Exhibit 5374 C,
Right.
which will make sense to all of us later when we're trying to do
Look, it's on the record.
Indeed.
I'm not going to try and work it out now, but thank you.
Thank you, Commissioner.
All right, we'll adjourn till 10 o'clock tomorrow. Thank you.